For
Sir, no out of turn mentioning. We have to wait for the page to be called. You have to be more patient.
Judgment.
Kindly take your seat. Just. Mentioning should I?
Better to make a mention.
Memo.
Memo, my lord.
Keep. But please specify fresh orders after notice.
Orders I have mentioned because there is the execution proceeding is continuing. So it has to be stayed. I have made a petition.
Unless you, it's better not to list the matter because I don't entertain. So what's the High Court
No,
reject?
my lord, here it's a land acquisition appeal. Appeal is
Okay,
pending.
appeal.
Yes. Date.
Appeal has been admitted.
Yes, my lord. Notice has been issued.
Orders pen yes only. Kebe early add karibe.
Orissa to.
Yeah.
Orissa.
Add kote hoche.
Pondor.
ठीक ଅଛି। କେବେ ଆପଣ ପୋଷ୍ଟିଂ ହେଇ ଜାଣିଛନ୍ତି କି ଡେଟ୍ ଜାଣିଛନ୍ତି କି?
Exactly.
20 ୱିକ୍ ରେ ଆସୁ
Aye.
ହେଲା।
Sir, I am opposite party number 4 in person.
Sir, which matter? First you have to tell the matter.
The matter is
Serial number. Issued ଅଛି।
ଆଜ୍ଞା
କୋଉ serial number mention
38 38
ମୁଁ ଅଛି 1 ରୁ 7 ରେ 1 to 7
ଆଜ୍ଞା
ତାର ଗୋଟେ ବୁଝାନ୍ତୁ।
I don't know.
Page 1 item 1 to 7
1 to 7.
4. Hello.
ନା ବୁଝି ପାରୁନାହାନ୍ତି?
Hello.
ବୁଝେଇ ଦିଅନ୍ତୁ। ଆପଣଙ୍କର ଯୋଉ ପେଜ ରେ ଅଛି ସେ ପେଜ ଟା ଡକା ହବ ସେତେବେଳେ ଆପଣ ନମ୍ବର ଟା କହିବେ। ବୁଝିପାରୁନାହାନ୍ତି?
ମୁଁ ଖାଲି
ଶୁଣନ୍ତୁ ଆପଣଙ୍କର ତ ଆପଣ ହଉଛନ୍ତି ଓକିଲ ମୁଁ ହଉଛି ଜଜ। I will conduct the court or you will conduct the court. ତେଣୁ ଆପଣଙ୍କ ଯଦି ଏକଥା ବି ବୁଝେଇଲେ ଆପଣ ତା ବି ଶୁଣିବେନି ମୁଁ କଣ କରିପାରିବି? ଆପଣଙ୍କର ଯୋଉ କହିବା ପାଇଁ ଆପଣଙ୍କୁ ତ କେହି ମନା କରୁନାହାନ୍ତି। ଆପଣଙ୍କୁ ମନା କରା ହେଇନି। ଆପଣଙ୍କ ଆଗରୁ ଅନ୍ୟ ଓକିଲ ମାନେ ବି ଅଛନ୍ତି। ମୋର ଯଦି ଗୋଟିଏ ମ୍ୟାଟର ଥାନ୍ତା ତାହେଲେ ଠିକ ଅଛି। ଟିକେ ଧୈର୍ଯ୍ୟ ଧରିବାକୁ ପଡିବ ଡକା ହଉଛି। Are you hard of hearing, Mr.? You are hard of hearing?
ନାଇଁ ସାର୍
Then ବସନ୍ତୁ। Item 4. Mr. Brahmakesh Tripathi for the petitioner.
My lord.
Efforts of the matter was heard at length on 15/5/2024. The facts as well as the propositions of Katha Huntuni. Mr. Nanda, stop talking. No discussions. ଯେ ବୁଝେଇ ହବନି ଆପଣ ବ୍ୟସ୍ତ ହୁଅନ୍ତୁ ଆଉ ମୁଁ ବୁଝେଇ ପାରିବି ନା ଆପଣ ପାରିବେନି କଣ ଲେଖିଲେ were noted ଆପଣ କୋର୍ଟରେ କଣ ଚାହୁଁଛନ୍ତି
Withdraw.
ରଖନ୍ତୁ ତାହେଲେ ଅର୍ଡର ଡାକିବାକୁ ପଡିବ ଆପଣ ବଢିଆ ଠିକ ଅଛି ରଖିବେ your presence is noted, not difficult. What we have to pass the order mentioning the order pass kale kemti ho then 5 to 7 then 8 to 6 17 page 2.
My lord, item number 13, pray for next week.
13.
Yes, madam. 13.
You are Mr. Karna. You are not Karna.
My senior.
You look like Arjuna. What's your name, sir?
Ranjan Dongri, my lord.
You are Mr. Ranjan Dangri for the petitioner. The matter is mentioned by the Lord Counsel for the petitioner seeking adjournment in absence of the seeking adjournment. Stop.
Yes.
Earlier, the matter was heard on 20/5/2026. The propositions of law and facts were noted. Stop. The petitioner had adjournment to answer the deliberations as noted in the said order. To grant further opportunity, the matter shall be listed for fresh admission in the week commencing 3/8/2026.
Item
Page to 8.
14, my lord. Item
14.
Yes, my lord. I am on behalf of Mr. Nanda, my lord. His father is seriously ill.
Your name, sir?
B.K. Ponda, my lord.
So B.K. Ponda on behalf of Mr. Nanda for the petitioner. The matter being listed for fresh admission is mentioned on behalf of the Lord Counsel for the petitioner. on ground of personal difficulty. Earlier, the matter was heard at length on 15/5/2026. The facts of the case as well as the relevant case law were discussed. The petitioner, the learned counsel for the petitioner had adjournment to address further. Stop. Para to grant further opportunity to the petitioner, the matters have been listed for fresh admission in the week commencing. 3/8/2026.
Interim order. Interim order may be continued.
The interim order it is reiterated. Dated 15/5/26. The adjournment order. ଆପଣ କେବେ କହୁଛନ୍ତି? 3/8. Shall be adjourned beyond 10/8/2026. 6 ରେ ସପାରା ଅଛି ନା ସେ ଯୋଉ ଡେଟ୍ ରେ ପାରା 6 ସପାରା ବି ପଡା ଅଛି. Yes.
My lord, item number 17,
17. What's your name, madam?
Ankita Swine.
Ms. Ankita Swai for the petitioner. The matter being listed for fresh admission is mentioned by the learned counsel for the petitioner seeking adjournment. Earlier, on 14/5/2026, when the matter was listed, was heard at some length. The learned counsel for the petitioner had adjournment to obtain instruction and file affidavit on behalf of the petitioner as indicated, as directed in the said order. Only. I had adjournment. Yes. I'll file a bit credit. To obtain instructions. तापर file affidavit कटिएगा तापर बोलो stop. To grant further opportunity to the petitioner, the matter shall be listed in the week commencing 3/8 for fresh admission in the week commencing 3/8/2026.
Page 3, 18 to 28.
Item number 19. So I'm difficult to appreciate.
You are Mr. Lenka.
Yes, ma'am.
So Bhuvanananda Lenka for the petitioner. 19, sir.
Ma'am.
20. The matter being listed for fresh admission. Under the heading fresh admission is mentioned by the learned counsel for the petitioner seeking adjournment. Say defect गुड़ाक remove कले.
Well.
He submitted that केमती कले registry record दीचंदी.
Well.
He submitted that typographical errors have been corrected in the meantime. The typographical errors in the petition have been corrected in the meantime. The matter shall be listed for fresh admission in the week commencing.
Well, can it not be taken up next week?
Next week, that is a next 20 week. 45.
Well.
145 also. And we are having some, I mean, like yesterday, the day before yesterday.
My lord, yes, it can be taken up yesterday.
27 रे 141 टा अछि 22.
My lord, at your
ଆପଣ
at the convenience of
27 साथ रखुन.
well.
We commencing 27. Yes, call करंतु.
22, 20.
20 ରୁ 28.
Lord's item number 28 on behalf of HN Mahapatra kindly argue in this matter.
Lord, I am for the very objective. So my execution proceeding has been stayed since last 2 years. It is in due of 11,48,000. It has
State
been
by this court.
no, not by this court, Your Lordship. By coordinate bench, Honorable Court.
No, of course, this court,
My lord,
not this bench.
my lord. There is a due of 10,48,000. I have filed an IA for modification. The permitting me to proceed with the execution. That has been stayed. And since 2024, so I pray, my lord, let it reach. Or let them.
Cannot be granted.
Lordship, my lord, senior is out of
He is
station.
also equally allotted and senior to you. Is he not is he not learned enough to be a lawyer and not senior enough to argue the matter? That is a so
Lordship,
compliance of the interim order has not been done also, Mr. Misra.
That is done. 1 lakh deposited 2024. That is that. Thereafter there is a due of 10 lakh 40,000. 11,
24 रे 1 lakh ଦେଇଛନ୍ତି
24.
କୋ order ଦେଇଥିଲା 1 lakh 3/24 ରେ
ଆଜ୍ଞା 3/24 ରେ ତାପରେ ସେମାନେ ଦେଇଛନ୍ତି ସେଟା. That I admit. Let them, your lordship may direct, let them pay some amount and the matter may be adjourned. He's a bank officer getting 28 lakhs per annum. That is his own.
should have been deducted from 10 lakh should be deducted from his salary
Again.
because I have been
Lordship,
I also want to pass popular orders, relief oriented quote unquote.
Lordship
But I need
has,
to find a law supporting me to not to stay
Depending
this
upon-
execution. To stay, I'm really struggling. Supreme Court has come down heavily.
Lordship has passed 2 orders depending upon that Jitendra Gandhi judgment that execution is similar to recovery of money proceeding is similar to execution.
And the Supreme Court. Supreme Court has done that.
Rahul,
A lot of research Supreme Court has done.
Lordship may direct, let them pay
That,
some.
Monday week रे आसु आपण काली डिपोजिट कर दियो हला I'll pass that order हला adjournment हबो बट आपण अपेक्षा करिया पड़ो मु जदी सब मैटर इति मेंशन डिक्टेशन देबी केमति हबो आपण कोडा अन्य कोर्ट रे जिबे ना कोन अरे योर लॉर्डशिप नो अन्य को लॉर्डशिप को कोर्ट को जिबे की अदल अपेक्षा करन तो ठीक adjournment दिया जिवो Mr. Mishra, please wait. ଆପଣଙ୍କର ଅନ୍ୟ ଜାଗାକୁ ଯିବୁ ନାହିଁ you will be attending other court so please wait ଆପଣ Mr. Mishra you are going to other court
I am waiting. I will
if you have then just mention it at 12:45 12:30. She seems to be a little bit anxious so and obviously your matter will not be taken up since he is seeking adjournment ठीक है 12:45 बेलू मेंशन करो
Page 4, 29 to 31.
32 page 5
Page 5, 32 to 37.
Item 35.
32 32 रे outside counsel he's not he comes from Noagarh actually. This will not be proper that if a outside counsel comes and he takes a date then we adjourn in his absence. Is he present? अच्छा नाहंती देखो ना आउटे जाओ he may come आपण नयागढ़ रे के अछंती जणै परिबे सर दिस इज आइटम 32 anyone present at Noagarh just send a message एटा केमती करछन सेटा और is it possible जे अन्य कोर्ट virtual group अछि ता आपण से ग्रुप रे आइटम 32 कोड नंबर हमर एटा अछि 9 आरएन बारिक ताका नाम अछि रविंद्रनाथ बारिक राइट yes next
33 to 37.
केता कहली
Item 35.
35
Kindly continue the stay proceeding.
35 रे आपण पिटिशनर पई
Yes, I am for the wife.
ए वाइफ पहले भी तो हबोनी ना अब वकालत नाम दउ पड़िबो
तो
आपण का पे वकालत नाम देले
wife ପାଇଁ the wife ପାଇଁ ଆମେ tag ଅଛି ସେଟା ତ ତା ଦେହରେ TRP ଟା TRP 1 2024 ଟା tag ଅଛି ମାନେ
टीआरपी सीआरएल 29 रे आपण अपियर करिवे नी
yes my lord but she is unable to proceed भिन्नाटा देई पारनांती मते
केते कथा आपण बुझिया पड़िबो कॉपी पाइछंती
yes ma'am
वकालत नाम पाइनांती
ना से
सेटा कहिबे जे वकालत नाम फाइल करिया पई
हां
दरकार समय योर नेम मैडम
सुकांती साहू एस साहू
ए अच्छी यस सुकांती सा ऑर्डर पास करे पड़े केते दिन रे वकालत नाम फाइल करिवे
One week.
10 working days. Date କରନ୍ତୁ।
Week on
ଆପଣ ଆଉ ଗୋଟେ କଣ କହିଲେ? Stay.
State continue.
Stay ଟା କୋଉ ପିଟିସନ ରେ ଅଛି?
Petition IA
କୋଉଥିରେ କୋଉ କେସ୍ ରେ ଆପଣ ଦିଟା କେସ୍ ଆପିଲ କରୁଛନ୍ତି?
against
ସେ ଲିଷ୍ଟ ଟା ରଖିନାହାନ୍ତି କି?
ଆଜ୍ଞା।
ଲିଷ୍ଟ ଟା ରଖିବେ। ଲିଷ୍ଟ ଟା ମ୍ୟାଡାମ ଦେଖନ୍ତୁ ସୁବିଧା ହବ।
again. Maybe see TRP see 1 by
TRPC 1 ରେ ଷ୍ଟେ ଅଛି।
हाँ IA टा continue होती state टा।
ଦେଖିବା ଠିକ ଅଛି ପଢିଲା ବେଳେ ଦେଖିବା। Yes. 36, 37. Yes, 38.
Sir, on behalf of Deputy Professor, sir, this matter should be taken up today immediately.
Enough today.
Yes, sir.
Okay, out of turn something only move. Would have marked that so many interlocutory matters like item 28 just now you saw Mr. Mishra for the objective. Out of turn hearing matters simply I am not taking up.
Sir, he is in
That
another
creates a I mean impression. I mean that does not create a very healthy impression. Out of turn hearing serially if it reaches definitely taken up. You have to be patient regarding this. But today, I think the bar has moved or something that there would be a full court is there. So I have to rise a little bit early at 1. That 1 up to 1:15 and 20, I cannot sit. So you must understand those things. And the determination is such that every matter, including fresh and orders, have to be heard. ଦେଖିବା go for the best. ଆପଣ ସେ କଣ କରୁଛନ୍ତି 38?
Melor, I am opposite party number 4 in person. For
ଠିକ ଅଛି CP
for modification of order.
out of turn sir ଆପଣଙ୍କୁ I cannot hear. You would have marked that the determination of the assignment is such that there are so many matters which involves the trials.
ସେଥିରେ ଶୂନ୍ୟ ଯିବ ଶୂନ୍ୟ ଆପଣ
ନା ନା ମୁଁ 38 ଶୁଣୁନି ମୁଁ ଏକ ଶୁଣୁଛି ନା
ଗୋଟେ ସେକେଣ୍ଡ
ମୁଁ ଏକ
ଗୋଟେ ସେକେଣ୍ଡ
ଆପଣ ଗୋଟେ ସେକେଣ୍ଡ ବସନ୍ତୁ ମୁଁ ମତେ ଏକ ଜାଗା 38 ଶୁଣାନ୍ତୁ
ସାର୍ ଅର୍ଡରଟା ଭୁଲ ହେଇଛି ଆଜ୍ଞା
ଅର୍ଡର ଭୁଲ ହେଇଗଲା
ଆଜ୍ଞା
ସେଟା ଆଇଏ ଫାଇଲ କରିବେ
ଆଜ୍ଞା ଫାଇଲ କରୁଛି ଆଜ୍ଞା
ହେଇଯିବ
ଆଜ୍ଞା
ଅର୍ଡର କଣ ଭୁଲ ହେଇଗଲା
ଅପୋଜିଟ ପାର୍ଟି ନମ୍ବର I am 4 ହଉଛି 4 6 ଜାଗାରେ ଭୁଲ ହେଇଛି ଅପୋଜିଟ 4 ଜାଗାରେ ଅପୋଜିଟ ପାର୍ଟି ନମ୍ବର 3 ର ନାଁ ବଦଳିଛି
ମାନେ ପଶିଗଲା କୋଉଠି କଷ୍ଟ ଟାଇଟଲରେ ନା ଅର୍ଡରର ଯୋଉ କ୍ୟାପସନ ରେ
ନାଇଁ ଅର୍ଡରରେ ବସିଛି
ଠିକ ଅଛି ସେଟା ଟିକେ ସାର୍ ସାହାଯ୍ୟ କରନ୍ତୁ ସେ ସେଟା କରିଦେବେ ହେଲା ଆପଣ କଣ ପଳେଇବେ ଆପଣ ବି ପଳେଇବେ
ନାଇଁ ମୁଁ ଅଛି
ତାହେଲେ ସାର୍ ଦିଅନ୍ତୁ ସେ କଣ କହୁଛନ୍ତି ଟାକରି କଲେ ଏକ ତାପରେ ଆଉ କଣ 38 ପରେ କଣ ମେନସନିଂ ସରନି କରା ଠିକ ଅଛି
39, 40,
mention memo you want a file memo
Yes, my
file it give it hand it over all memos are accepted already completed I am experimenting that allowing all memos I am experimenting maybe Barik is here Mr. Barik is mentioning your matter to be adjourned
My lord,
keep following
I am submitting from Noyad virtual court. My lord, I am submitting from Noyad virtual court.
they ଆସିଲା ବେଳକୁ ଇଏ ପଳେଇବେ ଏ ଭର୍ଚୁଆଲ ଆପଣ ହେଇଗଲେ ସେ ଭ୍ୟାନିଶ କରିଗଲେ ଭ୍ୟାନିଶ ଭର୍ସେସ ଭର୍ଚୁଆଲ Mr. Barik he wants to adjournment
No, sir, I do not want to adjourn the case, my lord.
you do not want to adjourn
My lord.
ठीक ଅଛି sir please wait
Yes, my lord.
page 7, 41 to 46,
Item 46 now. Close to file counter.
40 sorry
46.
46 posting कर दियंतु
two comes in 17.
I have informed.
17 8 नहीं obviously in a after notice matter if counter is not there there is no point in just waiting for it yes any other matter in page 7
Item 47.
47 yes sir
What's the last
On last occasion, they appeared.
Yes.
They took time to take instruction.
What is your matter, Mr. Tripathi?
On that day, I moved that
My
execution.
lord, I am appearing from
Your
opposite
Lordship
party
asked-
2 or 3, and my senior has admitted in hospital. So I may kindly fix a date for the hearing.
My lord, my anxiety is
Mention କରୁଛନ୍ତି ଶୁଣନ୍ତୁ ସାର୍ କଣ କହୁଛନ୍ତି ଶୁଣନ୍ତୁ.
my anxiety is execution proceeding. On the last occasion, after hearing your say that they file a petition to extend the time, saying that this is pending before the honorable court. So you extend
Let me check. He is also
in the same light, order may be passed.
ଆପଣଙ୍କ ନାଁ ସାର୍? PR
Ranjan
Behra.
Behra. Ranjan Behra.
You are PR Behra.
Again.
Ranjan, okay.
My lord, kindly appreciate order dated
Satish
chair. As per my lord's direction, I also filed a petition. As
27 डेट କରନ୍ତୁ 47
We commence 17/8.
17/8 ୱିକରେ ଆସିବ. ଆର୍ଜେଣ୍ଟ ବିୟଣ୍ଡ 24/8 ତ ଅର୍ଡରଟା ପାସ୍ କରିବାକୁ ପଡ଼ିବ. ଆପଣଙ୍କର ୟେସ୍ ସୁବିଲା ଆପଣଙ୍କୁ?
Again, sir.
17/8 ୱିକରେ ଆସିବ.
Again.
ଅର୍ଡର ଆର୍ଜେଣ୍ଟମେଣ୍ଟ ବିୟଣ୍ଡ 24/8.
Again.
48 to 52.
My lord, item 48.
48, yes.
I pray for an adjournment.
ଆପଣ କାହା ପାଇଁ ସାର୍?
Opposite party member.
ପିଟିସନ ଗୋଟେ ପଚାରନ୍ତୁ.
କହିଦେବି।
ଖବର ଦେଇଥିଲେ?
ନା ଦେଇ କଣ୍ଟାକ୍ଟ ଲାଗି।
ସେ କାମଟା ମତେ କାହିଁ ଦଉଛନ୍ତି ସବୁଦିନ?
କରିଦେବି।
ଆଗ କରିବେ ନା ଆଉ। ଡେଟ୍ କରନ୍ତୁ. 48.
We commence 17/8.
Pardon to mention item 49, my lord. To
49?
claim for filing counter, my lord. My lord and senior is present here. Petitioner, my lord.
Ms. Patnaik is there.
My lord.
Yes, she's there. এটা তো হিয়ারিং ହେଇଥିଲା. କେବେ ଯାଉଛନ୍ତି?
2 weeks time, my
ପୋଷ୍ଟିଂ କରିଦିଅନ୍ତୁ ଆଜ୍ଞା.
We commence 10/8.
10/8 ୱିକରେ ଆସୁ.
oblige.
3/8 122 ହେଇଗଲାଣି ସବୁ ପାଇଁ. Yes. 50 to 55. Next. Mr. Das?
The last item 55.
55, yes.
My lord, this is a matter, the same requisitioning authority is the appellant in all the cases.
Okay.
The same order has been already passed. I just want, my lord, if
So
it
what
is
you do
possible
here?
today, my lord, it can be taken up.
No, what you do, you prepare those, carry out the changes in those for all,
My lord,
for 1, 2, 3, 4, 5, 6.
My lord. I'll
Carry
do
out the
that.
changes.
I'll do that.
And ଏଟାକୁ ନେଇ ଆସିବେ to be mentioned କରିଦିଅନ୍ତୁ. କାଲି ବୋଧେ ପରଦିନ ତ ବୋଧେ Monday.
My lord.
But ଆପଣ ଏଟାକୁ ସେଠି effort ଆଜି କରନ୍ତୁ.
My lord, I'll do that. I'll do the exercise. My lord, the senior is there for the railway.
The fast batch actually, this thing happened.
My lord.
15 days I worked on that, but everything soft copy was lost in summer vacation.
My lord.
So
Very difficult.
it was a Herculean task. And even still, I could not recover everything because one can never recover. If you go through that 6-7 times, 6-7 traps, you can never remember what has happened. So, ଆପଣ soft copy ରେ ସବୁଥିରେ ଆପଣ appear କରୁଛନ୍ତି Mr. Mishra?
No,
4 matters, I think.
in one case I am appearing. Other case, my lord, I will give a slip with your lord. I am appearing in 63.
But since you are the appellant in all cases, you prepare that
My lord, I'll do it in all the cases.
all the cases.
My lord.
And wherever the other side is there, you can consult. That I thought that Mr. Mishra can see that. But ଆପଣ ଦେଖେଇଦେବେ.
Again,
I'll give
Whichever
Right.
matters ଆପଣ ଯୋଉଟା ଦେଖୁଛନ୍ତି.
Again.
Do not have to prepare multiple copies for all. But simply prepare separate for each of the items.
My lord, I'll do.
Yes.
Okay.
Special notice, item 1 for judgment.
May I please?
Just one second. Just one second.
In this case, my lord.
One document, sir. Judgment document. ଆପଣ ବି ସେ ଯୋଉ ବୁଝେଇଲେ ସେ ବି ଗଲା ସେଥିପାଇଁ ଆପଣ ୟୁ ଲଷ୍ଟ ଅଲସୋ ୟୋର କନସେଣ୍ଟ୍ରେସନ ଚେମ୍ବରରେ କରିଦେବେ। The direction is the prayer was for directing the matter to be transferred from Kendujhar to Cuttack. It has been directed to be transferred to the Learned Judge Family Court Bhadrak. The parties shall cooperate in expeditious disposal of pending litigation, and they shall avail the information and communication technology initiatives if it is available. The petition shall disposed of with the aforesaid observations. नोटिस तो लगे हुए थे अच्छी लगा नोटिस तो लगा yes Mr. Lata.
Item 1.
This case, the brief has been transferred more than 10 years back from me, and I have filed a memo to delete my name.
So what you can do, you file memo.
I have already given memo
Yes.
to delete my name.
Okay. So you kindly take your seat. I'll pass out.
Hon'Ble.
Just sir. Petitioner none. No. The matter was the matter was presented before this court. On 7 February 2012 ହେଲା नहीं 8 February 8/2/2012 by order dated 29/3/2012, division bench, then having determination, took up the matter. Stop. On prayer being made on behalf of the Learned Counsel for the petitioner, OP number 2 was name of OP number 2 was deleted. Sound capture. The address of opposite party number 1 was stated not to be known before the division bench, and the matter was adjourned, directing to furnish correct address of OP number 1. Thereafter, the matter was listed before the Fourth National Lok Adalat on 14/12/2024. 8/3/2025 10/5/2025. On 9/7/2026, Learned appeared for the petitioner, and the following order was passed. Pursuant to the order dated 9/7/2026, the registry has intimated the Learned Counsel, who was earlier on record on behalf of the petitioner, मेमो ଦେଇଛନ୍ତି
मेमो बहुत 10 वर्ष तले ଦେଇଛି
10 ବର୍ଷ ତଳର ମେମୋ ହାଇକୋର୍ଟ ରେକର୍ଡରେ ନାହିଁ।
ଏ ରେକର୍ଡ ସହିତ ମୋ ନାଁ ଆସି ନଥାନ୍ତା।
ଆପଣ ଆଉ ଗୋଟେ ମେମୋ ଦେବେ ନା କଣ କରାଯିବ?
ଅବିଜାଲି ମେମୋ କୋଉ ଡେଟରେ ଦେବି? That is the problem.
ଆଜି ଡେଟରେ ଦେବେ ନା? डेट तो मुझे करें स्टे जदि नहीं था कैलेंडर चलनी ताले से क्षमता भी ना सेटा गोटे सेलेस्टियल इवेंट
सर मुझे लिखी दूची 10 years back
whatever
brief has been transferred.
Cast it. Who was on record? Who is on record? Who is on record on behalf of the petitioner? The efforts of the registry has yielded result. Sri Nanda Learned Counsel is present. The matter having been listed, indicating that the matter shall be disposed of. It is submitted by Learned Counsel for the petitioner. Learned Counsel Mr. Nanda. Learned Counsel Mr. S.J. Nanda that the brief was taken by the petitioner almost 10 years back. As far as his memory goes, he filed a memo indicating no instruction from the petitioner. Audio ta sepote on karibe se opesi bhai ro case chalchi se bokte bosile setu 32 unmute kale on perusal of the available records, perusal of the case records indicates that the memo is not available. The Learned Counsel submits that he shall file a memo. He shall file memo of date indicating the fact that he had the fact that the petitioner had taken away the brief almost 10 years back. But the memo filed by the Learned Counsel, Mr. Nanda, is taken on record. Scanned copy be updated. Apparently, the petitioner has no interest in prosecuting the matter. But in considered view of this court, no purpose should be solved in keeping the matter pending. After 14 years, it was presented. Audio tangara hochi. Mr. Barik.
Yes, my lord.
So you can come back at 1 because 32 is not being taken up. Now 1 is taken up. You have to wait.
Yes, my lord.
So because others will be waiting to use the VC.
My lord.
Because in VC only one matter can be taken up. So please, you need not come. You just keep a track when the matter reaches. Okay.
Yes, my lord.
From Noyagarh, so many cases, so many lawyers will be waiting in several courts, in high courts. Okay, your matter, because he mentioned, so I was searching for you because you are out session counsel. But then he vanished. When you become virtual, he vanished. So you come back when the matter is called.
My lord.
The petition stands disposed of. Copy of this order shall be forwarded to the Learned Judge Family Court, Kotak. To be kept in the records of CP number 6654 of 2010. Stop. If the matter has already been disposed of, if the CP has been, if the CP, Mr. Nanda, don't write a big sentence. You just simply write 2-3 lines. Don't spend time like a pleading. Still, if the CP has already been disposed of and the records have been consigned to the record room, the needful be done to keep the present order in accordance with the rules. Yes, next.
Item 2.
Mr. Kumar Mahapatra for the petitioner.
Item 2, Your Lordship.
Yes.
Permitted to withdraw, my lords.
Memo देवें
I'll fail, ma'am.
memo दियो. The matter was presented before this court on 16/9/22 being defective, it was listed on 21/11/2025 17/3/2026 to remove the defects. On 7/4/2026, further time was granted to remove the defects. And it was listed and it was directed to be listed on 29/4/2026, indicating the matter shall be disposed of. Thereafter, further time was granted on 29/4/2026 for removal of defects. So, on 85/2026, the submission that the defects have been removed were noted. However, it was submitted by the learned counsel for the petitioner that the petitioner remains incommunicado. Stop. And the following order was passed. After passed a court order. Today, the matter being listed for fresh admission. Memo of date is filed by the learned counsel for the petitioner, which states thus. The memo shall be taken on record, scanned copy to updated. The petition stands disposed of. Copy of this order shall be forwarded to the learned so and so to be kept in the records of so and so. The learned family judge Bhadra to be kept in the records of criminal proceeding number 1258 of 2016. Disposed of by judgment dated 16/5/2025. Yes. Next.
Item 3,
Pass over column. Recall call them.
item 5,
For the opposite party.
वेट करिवे पास ओवर करिवा ना नहीं अर्जन करता बस
Short date it also.
स्टेटमेंट तो আছে करे पड़े एडजस्ट करे पड़े
Last day they have a direction.
petitioner
file.
none Mr. Sahoo.
Emma
Sahoo for the opposite party to record action. None affects for the petitioner when the matter is called. The matter was earlier heard in presence of the learned counsel for the was heard on 29/6/2026 in register was heard on 29/6/2026 at some length. The facts as well as the propositions of law were noted. The petitioner was directed to file affidavit as indicated at paragraph 8 of the said order, which is reproduced here. Affidavit in terms of the said order has not yet been filed by the petitioner. Stop. In absence of the learned counsel for the petitioner, the learned counsel for the opposing party submits that the matter may be listed after a short interval. Stop. Alright. To grant further opportunity to the petitioner, matter shall be listed for fresh admission in the week commencing 3/8/2026. पूरे मेमो दीजिए मेंशन करते नहीं तो मुंह मार्क कर दिया और क्या मने पड़े देखो कॉल करो तो पूरा
item 4,
oh yes I have looked Mukesh Tripathi. ठीक है. Mention got this. So Mukesh Tripathi for the petitioner. The 15/5/2026 para 1, 2, 4, 5, 6. कितना लिख लेता? 7. On 15/4/2026, 15/5/2026. 15/5/2026, after hearing the learned counsel for the petitioner. The facts of the case as well as the propositions of law were noted. And the following direction was issued. Para 8. At para 8, produced here. Today, the matter being listed for fresh admission as directed. Memo of date is filed by the counsel for the petitioner, which states thus. Into bracket size. The memo shall be taken on record. Scanned copy be updated. Aji 15 तारीख ना. এটা ଆପଣ রিসিভ করছেন. The petition is accordingly disposed of. Copy of this order shall be forwarded to the Honorable Judge Family Court both to be kept in the records of criminal proceeding number 23/2023, disposed of by judgment at the Tini Bar Relief Service. Yes, next.
Item 6.
From 6, my lord, and the respondent number 2.
Copies are any?
My lord, copy has been served.
Yes.
Copy has been served, my lord. The matter, my lord, connected matters are listed for week commencing 13/7 only. Maybe it will come up on 17. The batch of matter, there are 6 matters arising out of same judgment. So it may come up with the same.
17 week astuchi.
My lord.
Achi, date achi. Correct.
No, my lord, it is 13th. Week commencing 13th. The direction was to list
13/7.
13th.
That's a distribution that's in.
Again.
But if 17 is declared to be adjusted holiday, then again,
my lord, I'm
this week effectively then it will be 2 working days.
True.
4 was as such a pressure, but now it becomes 2 working days. How to adjust?
Lord, I'm just putting
the
connected matters. The connected matters I'm writing it down.
Actually, I can't predicate.
My lord.
So let him verify. ଆପଣ ସିମ୍ପଲି ସେ କହୁଛନ୍ତି ଯୋଉଦିନ ଆର ମ୍ୟାଟର ଗୁଡାକ ଆସିଛି ଆପଣ ବୋଧେ ସତର୍କ ରଖିଛନ୍ତି most likely because it is not listed today. 1 day left in this week. If 17 is not is the adjusted holiday, then ଆପଣ ଯୋଉଦିନ ଆଣିବେ ଏଇଟା ବି ଆଣିବେ ହେଲା. What is the Yes, next please.
Item 7.
Sir, Ramdas Achari for the petitioner.
Here, my lord, the petitioner.
Typographical error रही तो correct करती है. The office has pointed out typographical error in order dated 15/5/2026. Wherein 382 the number of the case has been wrongly typed as 382/2026 instead of 382/2025. The digit, the wrong entry, that is numerical 6, shall be corrected as 5 in the body of the order as per rules. Yes, Mr. Achal.
Your Lordship, the good question is the husband and wife both are residing in Fulbani. They are working. Husband is working as a data entry operator and wife is a regular teacher, government teacher. And the proceeding is initiated by the wife here in Cuttack because she is having some not coming regularly, but casual visit is there to his parental house. That is why she has instituted the case here. Here, my lord, the difficulty of the husband is, my lord, to attend all the dates in Cuttack is will be difficult for him. So let the case. That is why I was praying, my lord, if the case is transferred to Fulbani, there will be no inconvenience to both the parties.
But you are not answering what we discussed on 24/2.
Yeah, that
I did not record that.
Lordship, I know.
So it is wife's choice. Indian Divorce Act.
Yeah.
Divorce Act, Section 10, 1869.
Yeah.
It's wife's choice. Or notice नहीं होता.
Right. Exactly. Other
Hard on it. But that day, Parth had argued. Then Sichandan, then Barik, then finally, they are not confident or what?
Lordship.
Your learned associates are not confident or what? Every time, now 3 of them have appeared. Now you are appearing. So Ramdas Acharya likhile. The petitioner before this court is the husband in the marriage. He seeks transfer of CP number 763 of 2024, pending before the Just Family Court Cuttack to the court of Just Family Court Fulbani. The CP number 7, the stuff, the said CP has been filed by the wife in the marriage under section 10 of CP ର କପିଟା ଆନେକ୍ସ କରିନାହାନ୍ତି କି
100
ଆଜ୍ଞା
page number 100
କଣ ଲେଖିବ section 10 section 10 of the Divorce Act, 1869, seeking a decree of divorce and dissolution of marriage solemnized between the parties on 30.09.2014.
2014. 2014.
2014. But it is submitted that both the parties to the litigation at Cuttack stay at Fulbani, and there will be no difficulty for the opposite party, the present opposite party. She has filed the CP. Present opposite party, who is the petitioner in the CP, to attend the matter at Fulbani, which is around 60 kilometers, Fulbani town.
235 kilometers.
This is 235 kilometers from Cuttack. Para issue notice along with this order. Requisites for issue notice to the opposite party along with this order. Requisites for issuance of notice by speed post with registration and proof of delivery shall be filed within 5 working days. The double date be fixed to 17/8/2024. The matter shall be listed for orders in the week commencing 26/8/2024. IA, hard-headed counsel for the petitioner, he reiterates his submissions as noted above. Issue notice as above, accept accept one set of process fee as well as postal requisites. The interim is directed that the returnable date as well as the next date of listing shall be as directed above. In the interim, it is directed that the CP number 763 of 2024 shall be adjourned to a date beyond the 2024 as will be convenient to the learned court in season of the matter Upon a prayer being made for the said purpose. Urgent certified copy be issued. That's with.
Great.
Item 8,
Ashok Kottan.
9,
Mr. Manoj Kumar Mahanti for the petitioner.
Here, my lord, that wife had filed a DV case at in the court of Lornetism, Jajpur.
DV case I am not allowing transfer.
No, here what my lord I'm saying. He's completely handicapped. He's unable to move one place.
Whatever. DV,
Well,
the statutory scheme is that
Yes.
you have to go through my judgment. Because I have considered the aspect because that family, that report, investigation report and that counseling and family visit, this is part of the domestic violence or prevention of domestic violence to Women's Act. So by transferring it to another place, it
for
cannot happen.
trial only, because for trial only, why I'm saying, my lord, he's completely handicapped and he's a primary school teacher and posted in his own village because he's unable to
So
move.
you have to address on DV. DV Act of provision jota what I have dealt with. So I'll find out that right now I cannot give you.
See that,
Let it be simply adjourned.
for trial.
The DV case is not only for trial. It's not only for trial. There are other aspects to it. So let
My
us
lord,
see.
she left because I am a handicapped person. Only that is the reason. And filed there at Jajpur.
So there is no proviso in DV Act that if the husband is handicapped,
No, there is no
the women who have suffered divorce, domestic violence, the case has to be transferred to the place of working of the.
Not working, my lord. I pray.
So because and it's an ameliorative provision.
I have prayed for afterward. Or your lordship to cut off my
125 I have not allowed, 125 or 144, and DV I have not allowed. So if you insist that I'll pass that order, not dismissing your application.
Kindly.
Because the problem is that I have to get over those provisions. If you go through the domestic violence prevention of whatever that big act, that caption, DV Act. So there it is very specific. And only for trial I will transfer to Athagad. Then what about the other proceedings pending before the jurisdictional person? Because the magistrate is defined, everything is defined. I have discussed that. I'll find it out. Apan kepe 2 weeks ପରେ ଆସିବ.
So 1 week after that.
Simply adjourn କରିଦିଅନ୍ତୁ. Commencing 27 week. 20 week. ଏଇଟା ତ 14 ହେଇଗଲାଣି. 27 week ରେ ଆସିବ କହୁଛନ୍ତି.
27 ରେ 24 week ନାଇଁ.
Specific date କଲେ ହବ. Today is 15.
27th ରେ ଆସିବ.
27th week ରେ କରିଦିଅନ୍ତୁ. Yes. Find out the judgment.
9.
Is 10?
item 10,
Your Lordship, in item 10, I'm appearing through DC. I'm a bit unwell today, that's why I'm appearing through DC, Your Lordship. Based on the last order, a fresh SR was done, as been indicated in the cause list. And it was been pointed out that instead of
text.
Your Lordship.
The office note. Mr. Kaushik Day, for the petitioner, the hybrid mode is there. The learned counsel being present in DC addresses, the court addresses arguments. The pursuant to the order dated 10/7/2026, stamp reporting has been made. The stamp report dated this 14/7. Stamp report dated 14/7/2026 indicates that nomenclature not correct. It may be registered as CRLLP. Accordingly, the petitioner shall take steps for the change of nomenclature.
Your Lordship, the predicament.
How much time, Mr. Day?
It will require 1 or 2 weeks, Your Lordship. But the only predicament which I wanted to point out, Your Lordship, is the connected RPFM, that is RPFM 272 of 2025. When it was filed in the last year, the same issue was being raised by the registry, and we had filed an IA in that regard for change of nomenclature. However, the honorable judge who was having that assignment, he had passed an order that is an IA number 419 of 2025.
Apart from the background, you read the order. Read that order.
Yes, Your Lordship. That is.
Bench.
Yes, Your Lordship. At para 4, the bench noted, learned counsel for the petition.
Read the order in entirety.
The heard learned counsel.
Again, you are jumping the gun. Ago gote eta sorry je ago. ଏଥିରେ କ'ଣ କହିବାର ଅଛି ଆପଣ ଏଥିରେ ତ ଆରଟା କହିପାରିବେନି ନା ଇଣ୍ଡକ୍ସନ ର କ'ଣ ହେଇପାରିବ ଏଥିରେ
No, Your Lordship, what I was trying to say, both are connected actually. That's why.
अरे स्टाफ रिपोर्टिंग कनेक्शन କିଛି ହୁଏନି शॉर्ट सर्किट ହେଇଯିବ it will burn out if you start connecting cases during staff reporting definitely the circuit will burn out ଆଉ ଏଥିରେ MCB ର କିଛି provision ନାହିଁ there is no miniature circuit breaker or RCCB which will trip ବର୍ତ୍ତମାନ କ'ଣ ଚାହୁଁଛନ୍ତି ଏଟା ସର୍ଟ ସର୍କିଟ କରିବେ ନା ଏଟା ଅର୍ଡରଟା କମ୍ପ୍ଲିଟ ହବ
ଅର୍ଡରଟା
ଠିକ ଅଛି steps କେତେ ଦିନରେ ନେବେ
within 2 weeks
the petitioner is permitted to take shall take steps within 2 weeks within 10 working days in 10 working days 15 working days 15 working the matter shall be the petitioner shall have liberty to mention last लिखी दियो तो next matter को आसंतु yes RPFM 272
of 2025 herein when it was filed in the last year, Your Lordship,
पढ़ंतु order टा again short circuit हे गला
order
17/9/2025
yes, Your Lordship. This matter is taken up through hybrid mode. Learned counsel for the heard learned counsel for the petitioner. This is an application has been filed for modification of the nomenclature from RPFM to CRLFP, being so pointed out by the stamp reporter.
Just when you are speaking, just speaking a less volume voice because it is echoing. Reduce your volume.
Okay, Lordship. Learned counsel for the petitioner submits impugned is the order passed in criminal execution number 21 of 2019, which is arising out of judgment passed in CRP number 52 of 2016. Though there was no need to file such an application, since the defect was pointed out during SR that the nomenclature is incorrect, to ensure registration of the case, so also listing of the matter, the petitioner had to file such application under compulsion. Accordingly,
Mr. Dey, kindly you have to stop here. It is your submission?
Yes, Your Lordship.
So now you filed a application in a pending execution case or from the judgment?
In that particular case, that is arising out of a main judgment.
Sorry?
The order impugned in those matter arises out of a execution case pending before the learned family.
Then why you are saying main judgment?
But I think that has attained finality. That is the
what has attained finality? Read your prayer. Read your prayer.
In RPFM 2025.
Mr. Dey, this is the problem when we try to assist you on everything because we have to trust you. The honorable judge trusted you. You read the prayer.
The petitioner therefore most respectfully prays that this honorable court may be pleased to admit the present criminal revision petition for hearing, issue notice to the opposite party, and be further pleased to call for the records of criminal execution number 21 of 2019.
How you are saying that it is a final judgment? The execution is still pending there. Execution 21 of 2019. Order dated 3rd July 25 and 31st March 21.
Yes, Your Lordship. That's continuing orders.
So what is the order? 3rd July 25? Place that.
That is at page number. That is page number 33, Your Lordship.
So, the execution is pending or disposed of?
I will take instruction from the local council in this regard, Your Lordship.
How can you? How can you?
Actually, Your Lordship, this is a transfer.
How it will alter your position? On the date you placed the matter, the execution was pending. Then look at the earlier order, March 21 order.
Yes, Your Lordship. Therein the learned court had directed that taking into the facts of the case.
Page 42. Page 42.
Page 32, Your Lordship. I think.
Balisi, Chari Dui, 4-2.
Yes, Your Lordship. Hence, the DDO District Welfare Officer, Malkangiri is directed.
Read the last line. Read the last line. Put up on author quiz. Put up on 18/6/21 awaiting compliance of the order.
Yes,
so when the execution was disposed of, which you are challenging before the court, for that you have to obtain instruction from the local council after filing the petition. Obviously, that you made a incorrect statement before the coordinate bench. Now this look at the provision.
Yes, Lord. 19(4) of the Family Court Act.
So kindly look at the petition, execution petition then. You have the copy. Have you filed the copy?
Yes, Lordship. That is at Annexure 3, page number 43.
Yes.
An application under section 125 subsection 3 of CRPC to execute
stop
the judgment.
You need not have to read further. Against a 125(3) CRPC petition, what is the remedy?
Under 19(4), section 19(4) of the Family Court Act.
What about CRPC?
Yes, Lordship.
125(3) CRPC applies or Family Court Act will apply?
I have to check and...
you have to check everything and make a submission confidently, wrong submissions. It has to be CRLMP. Similar adjudication. RPFM, WPC, CRLMP, both very similar. But in 125, how RPFM will lie? In a pending criminal matter under CRPC, how RPFM will lie?
Then,
no, what you submitted before the coordinate bench, you should have been careful. First of all, you gave an impression that it is not at all a final order. It is an interlocutory order directing compliance payment. The execution case is still pending there. If the final order is there in the execution, then you can challenge it by filing whatever you want. It is an interlocutory order. And now the question is that whether RPFM or CRLMP. Obviously, it is a criminal matter, CRPC proceeding. And the execution is by 125(3). How do you execute an order passed in section 24? CPC.
By filing an execution petition.
Yes. So obviously there is a difference. Though jurisdiction is exercised by the Family Court due to amendment in Family Courts Act and after Rajneesh versus Neha, but the provision is different. And High Court rules is very provision specific, act specific. Stamp reporting has been done on 14/7/2026. The petition arises out of a pending execution case under section 125 into bracket 3 of CRPC. That is criminal execution number 21 of 2019 arising out of C.R.P. number 52 of 2016. The said CRP was filed, the said CRP is a petition filed under section 125 CRPC. Decided by judgment dated चौदह 11/2018। ଆପଣ ସେଟା ଚ୍ୟାଲେଞ୍ଜ କରିଛନ୍ତି ଅରିଜିନାଲ ଅର୍ଡରଟା?
Not in this proceedings.
Who proceeding पढ़िनी आपण have you challenged that order? The answer is yes or no. Not this proceeding. What is this kind of answer? Or you are not aware?
I am not aware about. So I have to
the petitioner is also not sure whether the petitioner has challenged the judgment and order passed in the CRP 52 of 2016. View of the order passed by this court. Stamp reporting was done. In considered view of this court, the petition is against a interlocutory order in a criminal execution proceeding. The petitioner shall take steps for carrying out change of nomenclature of the petition in a period of 15 working days. You should not have, before arguing before the coordinate bench, you should have verified it. You created the impression that this is a order challenging a civil court order and it is a civil execution, but it's a criminal execution and it is still pending. Yes, next.
Item 11.
Pass over Kotha.
12.
The Ganesh Prasad Samal for the petitioner.
Petitioner filed this application under section 24 of the Civil Procedure Code to transfer the civil proceeding pending before the Learned Family Court Kadrapada to the court of the Learned Court Family Court Jaspur Mylord. The fact of the case before Mylord is that
You are just simply re-arguing the matter. You take notice. Our Learned Counsel for the petitioner. The petition was, the Learned Counsel was heard earlier on 29/4/2026. The following order was passed. Thereafter, being urgent, the Learned Counsel was again heard on. Thereafter, on 14/5/2026, the Learned Counsel for the petitioner had adjournment. Stop. Yes, from Kendrapada to Kotak or Kotak to Kendrapada?
No, Kendrapada to Jaspur.
The petitioner before this court is the husband in the marriage who seeks transfer of the CP number
58, 2026.
026, pending report the Learned Judge Family Court Kendrapada. Which was filed by him. He had filed.
Opposite party, husband.
Cool matter to move on. It's a samapti. Bina select. Another photo. Hey, wife in the marriage. ମୁଁ ସମାପ୍ତିଟାକୁ ସମ୍ପତ୍ତି ପଢିଦେଲି
ଆଜ୍ଞା
ଆପଣ ଶ୍ରୀ ଶ୍ରୀମତୀ ନ ଲେଖିଲେ ପ୍ରୋବ୍ଲେମ ହବ the husband in the marriage under section 13 into bracket I into bracket I dash A and I dash B, seeking dissolution of marriage solemnized on 14/12/2014 in the parties. Stop. Sir, ground कौन कहते sir?
Wife,
केंद्रापड़ा जाजपुर कौन ground?
sir, the petitioner wife feels unsafe to go to Kendrapada, my lord. So far, the general, my lord, the convenience of the wife must be taken into consideration, my lord.
Who provision that?
As it is also, so far the wife is concerned, my lord, she is
safety feeling or convenience, who provision that? On
the last occasion, your lordship put this question.
I seek your assistance.
The subject of law is very vast. There is no aid to it.
Okay,
Then the second one, sir, what happened, sir? What happened in this case, my lord?
अरे आपण टिके सर मु कोन बड़ पटरे कोइ परिबेनी मु भी कोइ परिबे बट आपण तो बेसिक जिंसटा जाने चाहूची आई वांट द फाउंडेशनल प्रिंसिपल्स ऑफ लॉ जे कोतरे आपण कन्वीनियंस
सेतिरे सर जो सेक्शन 24 रे
आई विल असिस्ट यू आपण को रहउचोती वर्तन कोठी भाई
मु रहउ जाजपुर
का पगर रहउचो
बापंग पगर
मेंटेनेंस पाउचो कि नै
मेंटेनेंस तो 6000
पाउचो
आया
तो से ग्राउंड रे परिबे he submitted that आपनकर ये minor child कोठी रहउचोती
मो पकर
he submitted that after the parents of the petitioner has run into rough weather, she stays with her parents. She stays at her paternal home at Jajpur, in a village in Jajpur.
Sir,
in a village in Jajpur, along with the minor child, she finds it difficult to attend the matter at Kendrapada. Stop. Issue notice to the opposite party along with this order. Requisites for issuance of notice by speed post with registration and proof of delivery shall be filed within 3 working days.
My lord.
Returnable date be fixed to 17/8/2026. The matter shall be listed for orders in the week commencing 24/8/2026. आइए 113/2026. I wish I can give that reason actually. Very good. Law is such a subject I did not give any reasons.
It is just like Ocean, sir.
Just go by my if said exit. This will become so judging becomes so easier then. I found somewhat difficult to submit also in court.
Yes,
because trying to grapple with the enormity of provisions and case law. All right. The hard-headed counsel for the petitioner, he reiterates his submissions as noted above. So notice to the opposite party as above, accept one set of process fee as well as posted. Returnable date as well as the next date of listing shall be as directed above. As an interim measure, it is directed that CP number 58/2024 pending before the learned judge, Family Court, Jajpur. Kendrapada, na?
Kendrapada, sir.
Kendrapada. Shall be adjourned to a date beyond 31/8/2026 as would be convenient to the learned court in season of the matter upon a prayer being made for the state purpose. Urgent certified copy be granted as per.
Item 22.
Koda. 28. You are Miss Behra. Miss Behra.
Item 28.
Sorry. Apna ko naam?
Chinmay Sutar.
Miss Chinmay Sutar on behalf of Udarananda Mahapatra for the petitioner. Mr. Umacharan Mishra for the Asutosh Mishra for the
opposite party. Sole opposite.
The matter being listed for orders is mentioned on behalf of the learned counsel for the petitioner seeking adjournment due to personal difficulty. At the
That's fine.
Beginning of the day's proceeding, the learned counsel for the opposite party objects the prayer for adjournment, stating that after compliance of the interim order dated
3/9/2024.
3/9/2024, the petitioner remains in default of the amount due, which till date comes to around 11 lakhs.
10,48,000.
10,48,000
My lord.
towards monthly maintenance granted by the learned judge, Family Court, Bhubaneswar, in CRP number 142 of 2012. The learned counsel for the petitioner seeks extension of the interim order when adjournment is granted, which is opposed to by the learned counsel for the opposite party. The interim order is extended reluctantly, subject to the petitioner depositing rupees 2 lakhs.
Let's see instruction by ticket.
Instruction को कौन पैसा दे परिबे आपण दे परिबे
tomorrow by
पैसा पत्र मैटर रे करंतुनी पैसा पत्र मैटर रे नेवर आइडेंटिफाई योरसेल्फ विथ योर क्लाइंट से जदी देबेनी तांको कथा से बुझिबे ना आमे कोन ता कर परिबे किछ कर परिबे सेम आंसर व्हेन ही अपीयर्स फॉर द हस्बैंड ही आल्सो मेक्स द सेम इंस्ट्रक्शन ने भी पैसा दे परिबे कुछ परछन this execution matters you have to read and understand what we are doing. 2 lakhs within a period of 15 days. The prayer for extension of interim order by the petitioner in a prayer for extension of interim order interdicting execution case has to be considered in terms of the law laid down by the Honorable Apex Court in Gandhi versus
That is, I'm my lord.
Rahul Saha versus Jinendra Gandhi.
Eithre, your lordship, this is the order. Eita tika dei diyantu aଜ୍ଞା eithre reference pura entire matter has been done. ଆଜ୍ଞା
RPFM 15/2026. Mr. Mohanty's matter ଆପଣଙ୍କ matter ଟା
ନା ନାଇଁ ମୁଁ ଆଜ୍ଞା ସେ order ଟା ନେଇଛି.
coincidentally is there. ଆପଣଙ୍କ matter number ଟା କାନି ସେ ଯୋଉ case number ଟା କେତେ ମୁଁ interim order ଆପଣ mention କରିଥିଲେ ସେଟା କଣ ଆଜି ଆସିଛି 183 27 ରୁ ସେ ଅଟକା ଅଛି detail judgment Rahul Saha versus Jinendra Gandhi
ଆଜ୍ଞା
ସେଇଟା thank you Mr. Mishra, thank you Mr.
ଆଜ୍ଞା
PFM 183/2022 टाइटल लिखा है जजमेंट डेटेड 12/2/2026 राहुल जिनेंद्र कुमार गांधी (2021-6 SCC 418) टाको सुप्रीम कोर्ट लिखिबे रवि नारायण मिश्र वर्सेस हरप्रिया आचार्य judgment dated 12/2/2026. The learned counsel for the opposite party also relies on the order of this court dated 15/1/26 in RPFM number 15/2026 into bracket Pahali Kumar Naik versus Rita Naik and another. এটা লিখি দেন না আপনি দেখি देखता हूँ देख उसे देख लेते so Mishra just he'll write it down
ठीक है
ভিতরটা আছে জগন্নাথ yes Miss Sutar you have to understand this position in the execution process this court cannot interdict serious observations by the Supreme Court and Supreme Court has made it 142 circulated throughout the country. Must understand. Apart from Rajneesh versus Neha, Rajneesh versus Neha is very elaborate on this execution part. Very elaborate. Process versus Neha Kapur. Intellection. Intellection process versus Neha, you know it. What is the difficulty? ଆପଣଙ୍କୁ ମୁଁ ଅଧିକା ସମୟ ଦେଇପାରିବି. I think that Mr. Misro will agree. Because he doesn't want this matter to linger and no amount being paid. So ଆପଣ ଯଦି ଦେବେ ତାହେଲେ ଦିଅ, କାରଣ ଏବେ ତ 2 ବର୍ଷ ହେଇ ସାରିଲାଣି. Mr. Mahanti's case I think was much more. 6 ବର୍ଷ ନା କେତେ? 5 ବର୍ଷ. So I have to follow my own.
Kindly give me 1 month. 1 month.
ठीक ଅଛି ନିଅନ୍ତୁ. Order subject to the petitioner कौन लिखे? Order that. Sorry. नहीं मैं इतना पूर्व डेट का ना 15 दिनों 15 days within a period of 6 weeks करो. प्रथम दिन सेटा आपण बुझिया कथा आपण जो वर्तमान 24 रे केस फाइल कि 26 रे वर्तमान सेटा आलोचना चली छी. That we should not spend time. Time is valuable. Would have marked somebody is mentioning that आपण matter hearing करूँ, but we are taking up your matter. It's not nothing. No law is discussed. Nothing is discussed. Next week the matter shall be listed for orders in the week commencing. आज कितने तारीख होगी?
आज
15. 6 weeks के लोग होंगे. 15 हेले अगस्त 15 ही. We commencing 31 8 कर दियो. More than that about friend.
My only prayer is that on deposit that may be released in favor of the
depositing in the executing court.
That may be
deposit.
In that may be
release हे जो. अपन execution अच्छा है advantage. अपन that cannot be done here. And if it is done here, then it is gets more complicated.
On deposit, executing court may
deposit shall be the executing court shall
release it.
At the cost of repetition, at the it is further clarified that the learned executing court shall release the amount in favor of the decree holder in the execution matter, in the execution case on deposit of the state. आपण ताको मोटिवेट करंतु से एबेटू 50,000 लेखा दियंतु. सफिशिएंट टाइम आपण देगलेन 1.5 मास टाइम नै गले. ताको सेपरेटिविटी भावंतु. 50,000 लेखा जदि देबे एटलिस्ट
देई परियो टिके काइंडली. Your may kindly see
bank manager तो
declaration that he is getting 28 lakhs.
कोन करिया?
देई परियो छ ताको भाई.
नहीं सेटा से डिडक्शन करियार थिला. मंथली डिडक्शन नहले मैटर केबे छेडी बन.
My lord,
it becomes actually fishing expedition. Today somebody while catching fish fell into the river. That was the morning news. Luckily within the gate. And for vegetarian people, fishing expedition is always difficult. जमा सॉरी बनी ये जावरी चलिबो. Definite नहले this become very problematic. Yes, next.
Item 15.
Being a youngster, Mr. Misra, she should have some advantage. She had the advantage of adjourning the matter, but she's a youngster. She should gradually, she was so apprehensive. Yes. Your next question?
15.
Pass over for you.
16.
Madam?
My senior.
Madam, Sthiti Pragya.
Sir.
आपन का ना स्थिति प्रज्ञा
16 आइटम सबिता कुमारी बराल 16
सरिता
सबिता कुमारी बराल
पावर नहीं अपन पर आई एम सॉरी मिस सरिता कुमारी बराला ऑन बिहाफ ऑफ फिरोज कुमार राउत फॉर द पिटिशनर. The matter was heard at Length on 7/5/2024 7/5/15 ना 7/5 এটা ঠিক আছে ଆପଣଙ୍କର ବୁକ୍ ମାର୍କରେ 1/5 ଅର୍ଡର ସିଟରେ 7/5 କୋଉଟା ଠିକ ଅର୍ଡର ସିଟ୍ ବୋଧେ ଠିକ ଅଛି ବୁକ୍ ମାର୍କଟା ଭୁଲ ଟାଇପ ଅଛି Because had a length of 7/5/2024 the facts as well as the propositions of law were noted. Petitioner had adjournment. The learned counsel for the petitioner had adjournment to address on the issues noted. Thereafter, on 18/5/2026, the matter was again adjourned by the learned counsel for the petitioner. Today, the matter being listed for fresh admission, adjournment is again sought for. In absence of the learned arguing counsel, to grant further opportunity to the petitioner, the matter shall be listed for fresh admission in the week commencing. 3/8/2026. Yes, next please.
18th.
17টা adjourn ହେଇଛି 18 pass over କରିଦିଅ
20.
pass over
21.
Item 21 pass over.
pass over
22.
Am I audible, my lords?
Yes, please.
My lords, the petitioner challenges the action of the opposite parties, my lords, in issuing the order and, my lords, also the garnishee order. My lords, here the case is, my lords, your lordship may kindly see Annexure 1. The petitioner took registration, my lords, under the ESI Act to get some work order from other institution, my lords. He did not get. Thereafter, in the year 2019, he got a order of supplying coal to MCL, my lords. My lord, thereafter, my lords, this Annexure 1 was issued on 12/9/2024, page 12, my lords. The lordship may kindly see that is a C18 ad hoc notice. C18 ad hoc notice, my lords, indicating that 10 persons with their assumed wages 11,550, though nobody is getting that money anyway. So this was the notice issued. Well, pursuant to this, my lords, a 45A proceeding was initiated. 45A, my lords, but your lordship will find in 45A order this C18 ad hoc has given a goodbye, my lords. He has not proceeded on that since I don't have any employee. But he, what he did, seeing the balance sheet, he said, you have given this much of amount. That money, my lords, when the transport order he got, he has no vehicle, my lords. As an earlier case, my lord, he was contacted the vehicle owners and paid them the charges. And the vehicle owners, they used to pay their driver, cleaner, whatever. So I am not responsible for all those things. However, beyond this Annexure 1, they have passed the order, and my lords, the garnishee order has been issued in my absence, and the bank has already, the position is bank has already sent 1,37,000 to your lordship will find page 4, I'm sorry, Annexure 4.
What is the total demand?
Total demand is 1,37,669. 1,37,069.
They have I mean, accepted, they have got deducted that amount from your account.
Yes, ma'am. Yes,
the entire demand has been received.
Yes, my lord. Demand has been received by the SA Corporation. Now, my lords, I have
go in appeal.
No. I am filing this writ application since the order Annexure 4 is not maintainable. I mean, Annexure 2 is not maintainable, my lords, and no opportunity was given for hearing and all that.
Challenging the recovery also.
Yes, the recovery, because recovery I am challenging, but I have not made the bank party because they have done their duty. Money has already
received that money.
Yes, I have filed an IA for.
So my query is that whether is it worth keeping the matter pending here, or it should go to the employees insurance court?
No,
Because they are that 3 year if it is also not, I mean, it has passed. But since there is lack of notice, so I am directing condonation of that 3 year period.
No, Annexure 2 is not maintainable, which is, and I have not received Annexure 2. My lords, Annexure 2.
No, I got your point. I am not differing with your submissions. But
Lord,
my contemplation is regarding the consequence as far as the legal remedy is concerned. So whether this court or the ESI court,
this court, my lords, if it is sent back to the authority for reconsideration, my lord, then I'll get back all my money with interest. So that is why I filed an IA that let them.
Copy servici.
Yes, ma'am.
Again, I have given the copy.
Can be remanded, Mr. Tripathi?
No, my lord.
No, not today. I'm not today.
Not today.
But I'm just discussing with both of you.
Let me take instructions, ma'am.
Definitely.
Okay. So any order, the earlier transporter order you are having, can you carry out the necessary changes?
No, and I don't have, because I have not been given opportunity.
Transporter where is supplied.
My lord, the order is very clear. 5 opportunities have been given.
That is not important.
All the days the petitioner appeared.
Mr. Tripathi, suppose they issue a notice to you.
Yes, ma'am.
Mr. ND Tripathi is issued notice, give you 50 opportunities. How will you answer? Because you are not there. The point is that after that C18 notice, straight away 45.
That 45 order was passed after providing.
I mean, it is only a case of as you apply a garnish to a.
No, my lord, that is the law. Because the law is that without affording opportunity, order cannot be passed.
No, I'm not there. I have crossed that phase.
My lord.
Now, ESI notice is issued to Mr. Tripathi.
My lord.
You give him 50 opportunities.
My lord.
He doesn't appear.
No. In each date, he appeared and sought for time.
What since I am presenting a hypothesis, you are finding it difficult to understand. I am saying that on first occasion, Mr. Tripathi also appears, or 50th occasion, he doesn't appear. What would be his stand? That I am asking you. That
order first.
By appearing, what he can explain.
He has
your point is also well taken. That 5 times he was issued notice, he did not appear, so we proceeded.
No, my lord.
No. Each time in this case, he appeared.
So what best can he explain? That I want to know. In case of a.
My lord, I am saying that he was noticed to appear and placed his case, produced document and placed his case. He appeared and did not produce any document and sought for time allowed. And in urgent date, he appeared and filed simply the 26 AS copy of 26 AS under IT Act and sought for time.
Mr. In fact, you have partly answered the question. A person who registers to get work from some organization, he does not get that work. Thereafter, he enters into a work with MCL.
My lord, without employment, a firm cannot be registered.
Correct.
And if there was no employees, how it was registered?
I find that there is a lot of generation of litigation in this branch, because this compliance part, notice part, they don't understand. They are not legally educated.
For that reason, opportunity
you have to train your brothers also.
Yes.
Start, both of you should, Mr. Misra, Mr. Ray, Mr. Tripathi should train the lawyers there, everywhere in India. I'm sorry, in Odisha, I'm so sorry, in Odisha. So that they understand what is happening. Well, every case is not traveling to High Court.
Take instruction, and I have prayed for 50% refund. Let him take instruction.
In all the rate applications, not particular this, all the rate application filed before this honorable court, all the rate applications are involved with factual aspect, and no point of law has been raised.
In fact, in that
Simply,
context,
we have not given
So,
opportunity.
employees court would be a better, fact finding court would be always a better place.
For that reason, I submitted earlier a decision of the Honorable Supreme Court, that is Fiber Bangalore, 1997, 6 SCC, 1 SCC 625 page number. That is answer to all the doubts my lord asking now.
1997, 1 SCC.
1 SCC page 625. And paragraph 4 to 6 is the answer to all the questions asked my lord.
Copy I'm having, Mr. Tripati I'm having. I'm carrying all the entire library. No difficulty.
In this case, my lord may allow me to take instruction.
No, yes. But ultimately, what can be done? Because I'm trying to kind of a general principle that we can follow as a court.
Right.
Mr. Somnath Misra for the petitioner. The petitioner before this court is a proprietary firm.
Yes, ma'am.
Yes, my lord.
The proprietary firm engaged in. I have to dictate the order after I return because I have to attend something.
My lord.
So, how much time, Mr. When it should come?
Rahu for which team counter ta devi.
And no further deductions. Of course, upon to sab nejaichanti Lokesh
That's why I have filed an application for refund. Let my learned friend take instruction. No coercive action ka tha wote khali just to satisfy.
No further deduction, no further coercive action.
Yes, ma'am. Yes. And here, my lord, interesting point of law is involved. Notice was issued C18, my lords will find. C18 is for 10 employees. This is the way, whether it is correct or not, that will be determined or not. But now, my lord, the authority is going away.
So I was in also vacation bench. I marked that in income tax matter about
yes.
So demand is handled by the assessee like that. At times, actually, it speaks volumes of how the professional is handling.
Yes, correct.
It is not filed by the concerned, not named professional.
Sir, that is there.
They come up that he failed. And charitable organization, they file, do not file the certificate, and obviously the demand is raised. So at times I don't know how to handle this. When the professional, there is a failure in part of understanding the law and maybe failure in part of the person who is complying it. I'll come back.
Right.
ଆରଥର ସେମିତି ଟାଇପ ନାହିଁ ଅବଜେକ୍ସନ ଟା ଫାଇଲ କରିବା ପାଇଁ ଭେକେସନ ଷ୍ଟେ ର କାହିଁକିନା ଆମେ ମଡିଫିକେସନ ପାଇଁ ଦେଇଛୁ ପିଲାଟାକୁ ଦରମା ତାକୁ 15,000 ଟଙ୍କା ତଳ କୋର୍ଟ କରୁଥିଲେ ଇଏ କୋର୍ଟ ଏଠି 7,000 କରିକି ଷ୍ଟେ କରିଦେଲେ ବର୍ତ୍ତମାନ ସେ ଛୁଆ ସେତେବେଳେ ବର୍ଷ କରିଥିଲା ବର୍ତ୍ତମାନ 5 ବର୍ଷ ହେଲା ପାଠ ପଢୁଛି ପଇସା ଦରକାର ଅଣ୍ଟୁନି ସେଥିପାଇଁ ଆମେ ଭେକେସନ ପାଇଁ ଦେଇଥିଲୁ ଆଇଦର ମଡିଫିକେସନ କିଛି ଆଉ ବଢେଇବା ପାଇଁ ସେ ଅବଜେକ୍ସନ ସେ ବର୍ତ୍ତମାନ ଛୁଆ ଦଉନାହିଁ ତେଣୁ ଆଉ ଗୋଟେ ମୋ କହିବା କଥା ହଉଛି ଆସୁନାହାନ୍ତି ପରା ତେଣୁ ମୋ କହିବା କଥା ଗୋଟେ ଛୋଟିଆ ଡେଟ୍ ଦେଇକି ପ୍ୟାରେମିଟେଡ କରନ୍ତୁ ଯଦି ସେ ଅବଜେକ୍ସନ ନଦେବେ ଅନ୍ ଦ୍ୟାଟ୍ ଡେଟ୍
ଏଟା କୋଉଠି ମ୍ୟାଟର
ଭଦ୍ରକ
ବଲାଙ୍ଗୀର ହେଇଥିଲା ଆଇ ଥିଙ୍କ ହି ଇଜ ଦ ଫ୍ୟାମିଲି ଜଜ୍ ଦ ଲୟର ହାଜ ବିକମ୍ ଦ ଫ୍ୟାମିଲି ଜଜ୍ like yesterday I was telling the magistrate himself is 125
ବେଶୀ ହଇରାଣ କରୁଛନ୍ତି ଫୋନ କରି କଣ ହେଲା କଣ ଗୋଟେ ସର୍ଟ ଡେଟ୍ କରନ୍ତୁ ସେଇ ଡେଟ୍ ଲେଖି ଦିଅନ୍ତୁ ଯଦି ଅବଜେକ୍ସନ
ଆଜି ଦେଖିବା there is a possibility at least even if I have to rise early still there is a possibility to reach
ଆଜ୍ଞା
my lord item 37
yes
and Arjun I will take concern Mr. Patra
37 date karo to
Item
35, my lords,
35, yes.
35 was mentioned in the morning. I have my learned sister had mentioned it. The matter has now been posted to week commencing 27th. The urgency is that your lordship, I have filed an IA yesterday. Despite there being an order that an adjournment will be given in the criminal proceeding, the 125 CRPC proceeding pending before the lower court, they have passed an order. So I filed an IA for that. Lordship may call it in the next week. There is an urgency.
Cut you the next week.
Sir, order is 35.
हाँ सेटाको जोटा ऑर्डर टाको कोन पोस्टिंग कर कंप्यूटर कोर्स तो चेंज करियो हैला तो चेंज करी होबो ताले कर देउ तो आज होची केते 15 वीक कर दियो
Pardon, my lord. Item 41. Your lordship on 29/1/26. On 29/1/26 suggested that both the parties can go for amicable settlement on an endeavor by the councils. We have already consulted the councils and both have filed. They're filing to affidavits, praying your lordship to refer the matter to mediation so that that matter can be settled there.
Mediation, this is for maintenance. How mediator will settle it?
No, my lord. Your lordship.
Subsequently, your lordship, in the
what can be mediatory settlement in case of a maintenance award?
No,
that nobody is answering.
My lord, there is also
so they want to part ways. Let them part ways. But this is a maintenance amount, a decree of a court.
My lord.
How the mediator will sit over a decree of a court?
No, my lord. There is a matter pending before another bench, my
No,
lord.
this RPF, that's a different thing. You move that, you have to move that matter bench. That's a different thing.
Your lordship.
I'm yet to get an answer from any learned counsel that in case of a maintenance, what mediation can be made.
No, my lord.
In case of default, suppose you do not comply the decree, you have defaulted, or maybe he has defaulted. I'm not sure who is appearing.
I am the wife. I am for the wife. He is for the husband.
So he has defaulted. Yeah. So then what mediation I can do?
No, your lordship suggested that if there is an amicable settlement, then both these can be disposed of.
Settlement, the mediator is overburdened now. If they do not listen to the court in case of a compliance of a decree, can the mediate? The problem is that the mediator doesn't have that jurisdiction also. That is another problem. So unless you appear before, say something before this court that we have agreed, that can help in disposing of the matter. So sending to mediation is only indefinite adjournment, which this court should not grant. And more so in case of execution. In execution, what mediation can be done? 125(3) execution. But what mediation will achieve?
No, it is just the alimony.
The mediator will set aside the decree.
No, it is just the alimony amount which needs to be settled between both the parties. That your lordship on the last occasion.
Alimony settlement cannot happen in RPFA.
No, man, it cannot.
So you have to go to MATA court, fine, no problem. You talk there. So let it be urgent if you.
Well,
it's unlikely to reach during the course of the day.
We'll mention it in the Mata case.
41, you want a date? Yes.
Adjournment. Short.
Date kar do.
Full count is 17.
Last matter would mention correctly, Mr. Das. Seta kite matter? The 55 lekho. The matter is listed for hearing. Likhe appellant Ravin Das. The matter is listed under the heading. Your matter is over.
My lord.
Date koi dele ta? The matter is listed for hearing. The appeal is listed for hearing. Due to paucity of time, as the matter is unlikely to reach, is mentioned by the counsel for the appellant. And he submits that the matter, the identical matters have already been decided in several appeals by this court. He submits the matter may be taken up and disposed of. The matter shall be listed, marked as to be mentioned on 17/7/2024. To be mentioned in local policy? Yes, 17/7. Date is sure not actually. We are not ourselves not sure date is. But then pass over document.
Sir, 22 token.
22 token. Just 1 second. I was about to dictate one order, so because I have to rise. So appearance vice upon evening. That's more like Sobanath Misra for the petitioner. Opposite party blank. You have your seat. I'll just complete that order. The petitioner is a proprietorship concern engaged in contract jobs. It challenges the order dated order dated 15/5/2025 15 or 18 15/5/2025 passed under section 45 capital A of the ESI Act 1945-48 by the opposite party authority. Directing payment of ESI contribution of rupees 91,964.00 for the period from 08 from the period for the period from August 2019 to March 2020. Also under challenge, the recovery of rupees 1,37,069 by garnishee order from the account of the petitioner held at State Bank of India, Talcher branch in the district of Hon'Ble. Stop. He submitted that had learned counsel for the petitioner. It is submitted that prior to the issuance of the order under section 45 capital A, a notice in the form capital C 18 adopt dated 12/9/2024 was issued under sections 39 and 40 of the ESI Act. Thereafter, there has been no further adjudication by the authority before arriving at the demand determined against the petitioner. Issue notice to the opposite parties. Learned standing counsel, the Amarendra Prasad Ray, along with Sri N.D. Tripathi, learned counsel who usually appear for the opposite party authority. If present in court shall accept notice. Let two extra copies of the petition be served on the learned standing counsel during course of the day. The learned standing counsel shall obtain instruction and file counter on behalf of the opposite parties. The matter shall be listed for admission in the week commencing 24/8/2026. IE 1247 of 2026. Hard learned counsel for the petitioner, he reiterates his submissions as noted above. Issue notice as above. Copy of the application shall be served as the learned standing counsel. All right, it is submitted by the learned counsel for the. In the agreement is directed that the recovery of rupees 1,37, so and so shall abide by further orders of this court and shall be subject to the results of the petition. Obtain certified copy as code. The parties shall have the liberty to act upon the copy of the order obtained from the official website. I would like to add, no further amount shall be deducted from the petitioner, from the account of the petitioner, in view of the fact that the amount demanded, in view of the fact that the entire amount demanded has already been collected. Yes. Next.
Item 53 ଟା
53. 53 ଟା ଆପଣଙ୍କର after notice ନା fresh ଥିଲା?
after notice.
Date କରିଦିଅ।
Will commencing 17.
17. Yes, next.
Password item 3.
None appears for the petitioner, though the matter is called twice over. Once when it reached and again after resumption of the proceeding. Post lunch. 3 रे किछि मेमोरी का फाइल
Nice.
चलो 4 रे दिया इतना that dictate is the matter was presented before this court on 3/12/22 being defective was listed before the deputation to bracket judicial bracket close lodgement on 31/10/2025 for removal of defect. Thereafter, on 16/3/2026, it was listed before this court and further 7 days time was granted, taking a very liberal view after 4 years. On 15/2026, further 1 week time was sought for and granted on stop. The matter was taken up for fresh admission. The learned counsel was heard on 18/5/2026, stop on the same date. The facts of the case as well as the propositions of law were noted. At paragraph 5, the following was directed. At paragraph 6, the submissions of the learned counsel for the petitioner that the petitioner is not responding is also noted. Stop. Same paragraph 6 is reproduced here. So the Ajit order है first paragraph कर दियो तो paragraph 1 of 18/5/2026. What else? 1, 2 of 18/5/2026. 10 2 days of. View of the submissions of the learned counsel for the petitioner that the petitioner has not responded to the letter seeking instruction by speed post with registration as recorded in order dated 18/5/2026. It is apparent that the petitioner is not interested in prosecuting the matter. In considered view of this court, no purpose would be served in keeping the matter pending after 4 years, after more than 4 years. The petition is academically disposed of. Copy of this order shall be forwarded to the Honorable Judge, Family Court, one source CRP number 73/2014. Disposed of. To be kept in the records of so CRP number 73/2014. It's posted by judgment dated 31/10/2000. You put Balaswar. Now it's Balaswar. Yes, next.
Customer item A
And appears for the petitioner. So the matter is called twice over, once when it reached and again after resumption of the case proceeding. Resumption of the proceeding post lunch. Adjournment is granted reluctantly, granting further opportunity to the petitioner as the matter has been listed on 4 occasions since starting with 17/3/2026 till date. And on each date, the petitioner had adjournment. The matter to grant further opportunity to the petitioner, the matter shall be listed for fresh admission in the week commencing 27/7/2026.
customer item 11
May please, your lordship.
To Rohit Ranjan Ray for the petitioner, the matter was passed over when it was called. Thereafter, is heard. Thereafter, the learned counsel being present, the learned counsel for the petitioner being present is heard. Yes.
Your lordship, here the order awarding maintenance of the learned court below is challenged before your lordship. This here the court below awarded a total amount of rupees 18,000 per month from the present petitioner that has been awarded to the wife and 2 children, your lordship. And the basic lacuna of what this case is, your lordship, is as page 22. On a single date, on his absence, your lordship kindly have a glance to page 22.
Page?
Page 22, your lordship, order dated 23/2/2026. Your lordship got it?
22 you're saying?
20 page 22.
So, did you challenge that order?
Yes, your lordship. I have challenged the maintenance order, but what
should have challenged that order?
That was
This is too late in a day.
Yes, that was petition filed for your lordship. Petition filed for recall of that order, but that was not entertained, and judgment was delivered in a hurried manner.
23 hurried manner because we are hurrying them. No judgment in maintenance can be said to be hurried.
Yes, your lordship. Even the chance of cross-examination has not been given to the petitioner. No reasonable opportunity of hearing to adduce evidence on behalf of the petitioner has been afforded.
You are not to be sent invitation like marriage or something. You have to
No, exactly.
So you are why should you make a wrong statement regarding a legal proceeding?
No, your lordship. Your lordship is absolutely correct. But
you have to read order dated 23/2/2026.
Yes. Cross-examination of the petitioner is present and files are zero. OP has not paid interim maintenance dues. On call, OP is found absent.
So that is what Supreme Court has directed, striking of pleadings. That at least the court has not done that. In case of non-payment of maintenance, the Supreme Court has directed the pleading should be struck off.
But another one chance must be given.
So
on a single date.
One chance, but all out of law, extralegal.
No, it's a discretion of the.
Sir, it is not a matter of joke or fun we are making of judicial process.
No, your lordship.
You are saying one chance. The life never gives one chance.
Your lordship.
When was the direction for payment of interim maintenance?
Lordship, that was not included in this case, your lordship.
Sorry?
That order was not a part of this record, your lordship. I have not filed that.
You have to read to find it out. How can I find it out? It is not that I am preparing every case like
No. I have not filed.
10/7/25. Order dated 10/7/25.
Yes, your lordship. That is the final order, your lordship.
କଣ ଆଜ୍ଞା ଆପଣ disoriented ରହୁଛନ୍ତି କଣ କରାଯିବ? How can the judge will be more prepared than a lawyer? ଆପଣଙ୍କର ଗୋଟିଏ brief. Order ଦେଖନ୍ତୁ page
ଆଜ୍ଞା ଆଜ୍ଞା
page 1818.
ଆଜ୍ଞା ଆଜ୍ଞା ସେଟା ଠିକ ଅଛି ସେଟା ସାର୍ ଦ୍ୟାଟ ଇଜ ଦ
10/7/25 ଟିକେ ପଢିଲେ ଟିକେ ଧୈର୍ଯ୍ୟ ଧରନ୍ତୁ 10/7/25 ରେ ଅର୍ଡର ହେଲା
ଆଜ୍ଞା
so just kindly then go to your page 21
yes yes
para
I
7
got yes got it
para 7
yes your lordship
increment
the
now look at the order dated 23/2/2026
yes your lordship
and you are saying one chance
the
7 months is
from
not enough you remain
yes
in default for 7 months
yes
and you are
that
saying
span
1 month to be given
this
rather
span
the
is
court has more than indulgent not to strike up your pleadings
your lordship that
the
is your
court is
lordship
not at mercy of the parties.
no your
The way
lordship
you are portraying, the court should have went with a begging bowl from every month rather for 7 months.
that gap
Nothing. Argue on merits. If your
yes your
pleadings
lordship
have not been struck off, you argue on merits.
even yes your even your lordship the
Mr. Roy, to keep it simple because we are having a dearth of time.
yes
The way you
even
have
the
conducted yourself, you can never succeed. You deposit that amount.
your lordship I am
You
paying
have not paid the interim maintenance for 7 months. Then the court then deprives you of cross-examination.
one
Then
thing
you
one
say that
thing
at least one chance should be given. Now,
lordship
are you
I
paying
have
the amount?
I am paying the amount. That is my what I am trying to please
So
your
you
lordship.
file that affidavit. If you are paying, you
Yes,
file.
yes, yes. In my assets and liability statement, I have already stated that your lordship.
Mr. Rai, you have to concentrate when you are arguing. Your answer cannot be that I have stated in the assets and liabilities.
Lordship,
Paying the amount directed maintenance, are you paying? You are said yes. I said file affidavit. Then you are saying that assets and liabilities.
lordship, in that
If you are
affidavit,
having too many cases, then please come to court because you are unable to understand the question even. Have you paid? You are saying that yes, I am paying the maintenance.
in as per order of this honorable order of the lower court, I have not paid, but I am voluntarily paying. That is
Voluntary
why
or involuntary is immaterial. Your voluntary payments should be brought on record if I have not honored the decree.
lordship, it is in the record, page
So, Ray,
25.
the petitioner is seeking mercy or the court is seeking mercy of the petitioner?
No.
So you are an officer of the court.
Petitioner.
So
Yes,
you
yes.
maintain your stature.
Yes, yes.
The petitioner before this court is the husband in the marriage. He files by filing the revision under section 401 of the CRPC read with section 19 into bracket 4 of the Family Courts Act. He seeks revision of the judgment dated 24/2026 passed by the learned judge Family Court Khurda in criminal petition number 125 of CRL.P. number 125 of 2024. Criminal petition पूरा लिखा है. The said petition was filed by the wife in the marriage and two minor children born from the wedlock represented through their mother guardian. Under section 125 of CRPC, seeking monthly maintenance at the rate of
The court may I submit your lordship?
did not, sir. You are too confused to assist.
Lordship,
I am confident that I am not making any mistake.
Your lordship may keep it to any other date. I will satisfy your lordship.
So that I am not taking from dictations from you.
No.
So
How could I?
I have to do my work, not ask you for suggestion. Can I keep it to other day? That is not the question. So then you can give the money.
That lies on you.
I don't seek any permission from you. Rupees 10,000 for the wife, and 10,000 for each of for each of the children. The total amount becoming 30,000. Whenever you start arguing, just forget the whatever your client has briefed you. Straight away, common law.
Yes. That is the
Stick there.
Yeah, Lord.
If you start speaking the versions of your client, then it completely falls apart. Completely falls apart.
Awarding 11,000, that is going beyond jurisdiction. The
ଶୁଣିବେ ତ ଫେରେ କଣ ଲେଖିଲେ? Total amount claimed being 30,000. The petition was favored. However, directing rupees 11,000 to the wife and 4,500 to each of the children.
4,500 to petition number 2 and 2,500 to petition number 3.
4,500 to petition of jaha ठीक कहले आपण 4,500 to the elder children. I am really grateful that you have started concentrating. 4,500 to the elder child and 2,500 to the younger child. To support the prayer for revision, it is submitted by the learned counsel for the petitioner, referring to the orders passed in the proceeding, that the petitioner did not have opportunity in the opposite party before the trial, before the learned judge family court. He refers to order dated 23/2/2026. The said order is reproduced herein. The application was filed for recall of the order dated 23/2/2026, which was taken up on 17/3/2026. On 17/3/2026, the non-compliance of the order dated 10/7/2025, directing payment of interim maintenance. On 17 on 23/2/2026. 23/2/2026. Non-compliance of the order dated 10/7/2025 was noted by the court. On being asked, it is further submitted by the learned counsel for the petitioner that the petitioner is not complying with the order directing payment of maintenance. Total amount being 18,000. The learned counsel for the petitioner is apprised of the judgment rendered by the Apex Court in Rajneesh versus Neha, wherein it has been held that in case of non-compliance of order directing payment of interim maintenance, the pleadings should be struck off as a measure to enforce compliance. In the case at hand, the lauded court was, the lauded judge family court did not go to that extent and has considered the matters by considered the petition directing seeking maintenance based on the pleadings of the opposite party as well as relying on the evidence on record. For giving the finding on income of the petitioner, the learned family judge has relied on his employment and salary. His employment under Southern TPCODL. What like I said, his employment in subdivisional office TPCODL, Khordha Electrical Division. Salary, his salary being rupees 42,000. Income from landed property towards his share, rupees 1 lakh. Salary gross salary 57,004 टंका 57,004 net salary rupees 47,682. President versus complete sentence. We are to decree, only decree. It has been further held in Rajnesh Supra that the amount directed to be paid to the wife and children as maintenance is akin to a money decree. The petitioner is also, the learned counsel is also apprised of the provisions contained in CPC Order 41, Rule 3. The petitioner shall file affidavit giving the details of the payments already made, such as amount paid, mode of payment, date of payment, the total amount remaining unpaid, and how you would secure the amount to sustain the revision before this court. As prayed for, the matter shall be listed for fresh admission in the week commencing week commencing
36/7.
36/7/2026.
Yeah, the Lordship. Lordship, I filed an IA.
आइए तो बर्तमान जदि ऑर्डरटा जा हैला सेतु बुझि जाइथिबे
एग्जीक्यूशन प्रोसीडिंग ता बांध देबे कि कोन करिवे
बेकिंग बॉल धरि जिबे कोर्ट जिबे
सर सेक्रेटरी
ऑर्डर करिथिले फैमिली जज ही दे आर इन फैक्ट सीनियर मोस्ट जजेस इन द डिस्ट्रिक्ट बेकिंग बॉल धरि जिबे ना कोन
सर स्टे ता
57,000 रु 18,000 कले आपण ताकू स्टे पाई हाई कोर्ट स्टे करिवे the learned counsel the learned counsel for the petitioner seeks refers to the interim application is apprised of the judgment of the Honorable Apex Court in Genius, that is wherein the following has been directed. Rahul Shah versus Genius, so wherein the larger bill, the following has been directed. সেটা আমি quote করবেন. You must understand that High Court cannot interdict executions. There is a clear direction of the apex court in two judgments. The other one is
But he is a service holder, that's why I am paying you also.
obviously that is how he has to pay.
Yes.
I don't know why. I don't understand how the executing court is sitting over its execution when directed by Supreme Court. He should have directed 18,000 be deducted.
Yes, that is the procedure,
Yes.
Lordship. Till next date, your Lordship may.
No.
Otherwise, he will suffer, your Lordship. That in that
No,
period,
no.
he may be taken into custody.
For his suffering, I cannot invite comment from the Supreme Court, non-application of mind. For his suffering, I will stop reading Supreme Court or following Supreme Court.
No,
Well, the advantage there.
it's a service holder. That's
Court
why
is service holder should pay. Service holder now. How you read the brief? I have read the. He leads a luxurious life.
Your Lordship takes pain from me. I know, your Lordship, but if stay is not granted, then he will be suffer.
Stay is not to be granted unless paid.
I am paying some amount. I am paying to my kids and my wife, but they are claiming a higher amount. That is admitted by the court below, your Lordship.
You ask him to pay. He will not listen. He has no regards for you, Mr.
Your Lordship, if your Lordship permits,
the way he treats the family court decree,
your Lordship, if permits, go
he
just
treats
one.
much more contempt the lawyer.
Your Lordship, if
He
your
treats
Lordship
you as his
permits,
agent.
only I want to, your Lordship, kindly read
Sir,
page 25.
the amount due till date is that much I can specify for you. That exercise also I will do. The amount due till date in terms of the judgment and order date is 19/4/24 हिसाब करते हैं. Mr. 18,000 into amount till July 2026 to be 27 मास 18,000 गुणन 27 तापर लिखिन दैट इज फाइल दैट affidavit indicating how it secures the dispute. I'll rise for a few minutes because that other bench matter is I have to look into. So I'll come
Lordship,
back.
may just your Lordship kindly draw your attention to page
So
20.
you draw the kind attention of the client that he's in default of 18,000 को 27 गुणले केते होची. Yes, Mr. Sodak. 18,000 गुणन 27 ताकर काइंड अटेंशन ड्रा करंतु 486,000.
आज्ञा मु दोजी सर मासुको
तो काली आनंतु तो परदिन आनंतु परदिन आले मंडे दिन ऑर्डर हबो.
मासुक मु सर दोजी 6,000 तीन जनक पई प्लस पढिबा पई आ खर्च जो खर्च 1800
परिबा सेडा कहले का परिबा भी आपण आनथबे. मु कोन एटा हिसाब करी परिबा मेडिसिन तेल
ना सेटा मोर अछि असेम्पशन.
लेट अस नॉट मेक इट सो फनी. आपण का आगे जेति टंका जोडा दउचंदे 18,000 रु आपण 6,000 काटी देबे. तापरे परिबा सौदा ड्रेस सिनेमा माने अदर एक्सपेंसेस टीवी मोबाइल फोन कैन इट बी एडेड लाइक दैट. डोंट मेक इट दैट फनी.
सी इज ए वेल एजुकेटेड लेडी योर लॉर्डशिप.
आपण जदी 6,000 दउचंते स्टेट एफिडेविट फाइल करेगा 6,000 दउची Our area
that is in the affidavit.
lekha hai.
That is in the affidavit.
In terms of the decree, it is 4,86,000. You draw his kind attention. You see whether he is kind towards you or not. If he is not kind towards you, you feel free to be unkind towards him and
Your
don't
Lordship,
frustrate the court.
she is a air hostess. She is a well-educated lady. And
So,
she is claiming.
so you seek maintenance 125.
Lordship, that's what I am stated.
File
That
your
is,
125 maintenance. And
I have also income.
when you are submitting these things, please mark the age of the lady and the children. Before submitting that, she is a air hostess.
That is in the file. Your Lordship. That is in the file.
Mahanti, Maheshwar Mahanti for the petitioner.
I am filing a memo
Yes.
to withdraw the case.
The Learned Counsel
To
for
appeal or
the matter was
any
passed over
appropriate
to
remedy.
retreat. Thereafter is heard the Learned Counsel for the petitioner being present. Para one from order taken to this church of BC. After hearing the Learned Counsel for the petitioner elaborately on 30 Kudecha BC, the following order was passed: 2, 3, 4, 5, 6, 7, 8. Repeat कर देंगे. Court कर लेंगे, normal type में कर देंगे. The Learned Counsel for the petitioner had adjournment to make his submissions. Today a memo of date is filed by the Learned Counsel for the petitioner, which states thus. You have gone through Jalur Singh. In fact, it says that appeal is also possible. In some cases, appeal is possible.
Any other?
Let us see. Which states that the memo shall be taken on record, scanned copy be updated. The petition is accordingly disposed of.
Liberty to file.
No, this is not a bar. But because it is yet to be admitted,
Simply withdrawal.
the petitioner shall have the liberty to pursue any remedy available under law. Available and permissible under law. If so advised. This court expresses no opinion on the said aspect.
Password item 18.
Yes.
Pay for the short action.
This is P. Bastia for the petitioner. The Learned Counsel for the petitioner was had at length on 21/5/2026. The facts of the case as well as the propositions of law were noted. Stop. The sound capture codes. Next one. It could by you. Today the matter being listed for fresh admission. Adjournment is sought for by the Learned Counsel for the petitioner. In absence of the agreeing counsel, to grant further opportunity, the matter shall be listed for fresh admission in the week commencing 3/8.
Password item 20.
Now, the appeals for the petitioner, though the matter is called twice over, once when it is, and again after resumption of the proceeding post lunch. The matter was had at length on unfixed BC. The facts as well as the propositions of law were noted. The petitioner was directed to file affidavit as directed in paragraph 4 of the state order. So, to grant further opportunity to the petitioner, the matter shall be listed for fresh admission in the week commencing 3/8/2026.
Azure item 21.
Your Lordship, I'm on behalf of Advocate P. Panigrai. This is a petition of for fresh admission to seek restoration of a PLA case, Your Lordship. So actually, it had happened that unfortunately the counsel representing in the PLA case had passed away, and we were not aware of that. So the case has been dismissed on the permanent Lok Adalat, Barampur Ganjam. So we are trying to restore the case.
On that ground, how this court will take the cognizance?
So,
You
Your
must
Lordship,
understand that this has to be considered by the court itself. Dismissal for default is to be considered not by another court. It has to be considered by the court itself, which has passed the order. So you are challenging that default order.
yes,
So how can it be challenged if you are taking advantage of that? I hope you understand what I am saying.
Yes,
Little bit
sir.
nuanced. A petition is disposed of on merit.
So,
The petition is no, kindly appreciate this.
Yes.
Then you will understand.
Yes.
Petition is the last matter Mr. Mahanti was arguing. It was disposed of as he did not want to press it with liberty.
Yes, Lordship.
Now suppose you will challenge this order in Supreme Court. What the Supreme Court will say? That you have yourself withdrawn to seeking liberty to go to another if at all available. Now the court which dismissed the matter for default is not on merits.
Yes, Lordship.
So then you have to move that court.
Yes, Lordship.
Then what would happen? As a student of law, you must think in these lines. Keep your eyes and ears open, especially the thought process. The court which had default dismissed for directed dismissal for default,
Yes.
there is a specific clause actually.
Yes, Lordship.
There is a provision in CPC. So usually you will find that restoration is filed, restoration application is filed. In High Court, the application is CMAPL.
Yes, sir.
Correct. So why it is not a writ petition? So it is a specific jurisdiction also.
Yes, sir.
Now that court may allow your petition. You will be happy or still you will challenge it? Till now your conduct is that, your petitioner's conduct is that you will be happy because you are seeking the same order here. Now if the court dismisses that,
Yes, Lordship.
then you have to think what to do. So that stage has not come. Please discuss with your senior also.
I'll take instructions, Lordship.
What's your name, madam?
D. Nayak.
MS D. Naik. On behalf of Vaibhaswata Panigrahi for the petitioner, B. Panigrahi for the petitioner. The petitioner, by filing the writ application, has made the following prayer. Praise for restoration of the PLA case number 25 of 2017, which was dismissed for default by order dated 4/4/2023. The Learned Counsel is apprised of the position in law that if the petition was disposed of, the petition was dismissed for default on part of the applicant, the said court has to consider the application for restoration. Stop. C6 and has adjournment. The matter shall be listed for fresh admission in the week commencing 3/8. When the Learned Counsel passed away, you said that counsel passed away?
It was in COVID time during 2020, but we came to know in this year, in the April 2026.
Yes, next.
Obliged.
Serial 23.
23 mention करथिले I think Mr. Boral was sitting. Petitioner none. The matter was presented before this court on 25/1/2022. For the last more than 4 years, it remains defective. The defects, defective, the defects as pointed by sir having not been removed. Earlier on a 15/2026, four weeks time was granted by the when the matter was taken up by the depositor into bracket J Logima. Thereafter on 24/6/2026, this court had granted for the time to remove the defects, which has not yielded any result. Stop. To grant further opportunity to the petitioner, the matter shall be listed for orders in the week commencing. I think that job commencing. 27 indicating that the matter shall be disposed of. For defects not being removed for more than 4 years. Yes, next.
24.
Mr. S.K. Pradhan for the petitioner.
Limitation is there.
Yes, limitation is there.
No.
And compliance is there. Compliance of the decree. What is the amount defaulted?
No, it's continuing.
Continuing.
Yes.
Find that affidavit.
Madam,
କେତେ ଟଙ୍କା ଦଉଛନ୍ତି?
ସେ ଆଭରେଜ 4000 ବୋଧେ ମୁଁ ଇନଷ୍ଟ୍ରକ୍ସନ ନାହିଁ ଦଉଛି କଣ୍ଟିନ୍ୟୁ ଦେଇ ଚାଲିଛି ଏଠି ବି ଏକ୍ସିକ୍ୟୁସନ ଚାଲିଛି ଦେଇ ଚାଲିଛି ସେ କଣ୍ଟିନ୍ୟୁ
ସେଟା ଲେଖିକି ଦିଅନ୍ତୁ। IA 106 of 22 along with RPFM 72 of 2022. The petitioner before this court is the husband in the marriage. He seeks revision of the judgment dated Hon'Ble 2019 passed by the Learned Judge Family Court Noyagarh in CRL.M.P. CRL.MP number 08 of 2018 by judgment dated 15/2/2019. Disposed of by judgment dated 15/2/2019. The said CRL.MP was filed by the wife in the marriage and the minor toddler child, minor infant, 9 months, minor infant, and minor infant child born from the wedlock. Under section 1 from the wedlock represented through her mother guardian. Under section 125 of CRPC seeking monthly maintenance କେତେ 8000 ମାଗିଥିଲେ ନା କଣ?
4000
ମାଗିଥିଲେ କେତେ? କଣ ଲେଖିଲେ? At the rate of 20,000 for the wife and ₹5,000 for the daughter. Stop. Para, the petition was favored. However, directing payment of ₹4,000, 3,000 to the wife and ₹1,000 to the child. from the date of filing of the application, that is now 1/2018. When it counsel for the petitioner is apprised of the law laid down by the Honorable Apex Court in Rajneesh versus Neha, wherein it has been held that the amount directed to be paid to amount directed as maintenance to be paid to the wife and child is akin to a money decree. The total outstanding till August, till July 2026. Rupees 4,000 into 102 months. Equal to so and so. It is submitted by the Lord Counsel for the petitioner that the petitioner goes on paying rupees 4,000 in compliance of the Lord Counsel for the petitioner. It is submitted by the Lord Counsel for the petitioner upon instructions received that the petitioner on paying rupees 4,000 every month as directed the petitioner shall file affidavit indicating the details of payment made towards the area of rupees 80, giving the details such as date of payment, mode of payment, amount paid. The affidavit shall be filed by Thank you. So, to cost affidavit data. 4 lines, of course, it is 4 lines, but July ଆସିବ ନା କଣ? July ହବ ଏଇଟା ନାଇଁ ସ୍ୱାଧୀନତା ପରେ ଏଇଟା ଆସିବ ନାଇଁ affidavit will be filed by 31/8. The matter shall be listed 31/7. The matter shall be listed for orders in the week commencing 3/8. ଏତେ ଶୀଘ୍ର ବି ହବନି ଚିଠି ଦେବାକୁ ପଡିବ ଚିଠିରେ ନେବାଣିଆ କରିବେ It's high time that the lawyers should file maintenance also.
No.
For defaulting husbands.
সেটা তো মাতা ডাইভোর্স ବି ଚାଲିଛି ମାତା পেন্ডিং ଅଛି
এটা তো 125 ରେ କାହିଁ ଆର୍ଗ୍ୟୁ କରୁଛନ୍ତି ମୁଁ ବୁଝି ପାରୁନି including Mr. The statute of Narayan Prasad Parija, Doyen of Bar. We have been trained and so many of us have the matter shall be filed by 7/8/2026. ସେଟା ହବନି ମନା କରୁଛନ୍ତି filed by 7/8/2026. The matter shall be listed for orders in the week commencing 10/8/2026. ହେଲା Yes, just give me some time to your oath. Your matter is over, sir. Yes. Yes, please. Call Coram.
Item 25,
None appears for the petitioner when the matter is called. The defects as pointed by the registry shall be removed within a period of 10 working days. Copy of this order shall be forwarded to the Learned Counsel for the petitioner by the registry. The matter shall be listed for orders in the week commencing 10/8/2024. Yes, next.
26,
26 on behalf of Mr. A.R. Das. My lord, I am for the petitioner husband.
Mr. Acharya's concern is that actually 26 there is an interim order directing payment of some amount. That is not adequate. So he has filed a IA. You inform Mr. Das that you obtained instruction on that and to what extent it can be increased. Maybe not to the extent it was directed, but at least some kind of some arrangement has to be made for the growing needs of the opposite parties. Especially the child who has grown up and declares.
We'll file the objection in the
Objection ସେଥିରେ କ'ଣ କରିହବ?
19/5 ରେ ଆସିଥିଲା ସେମାନେ ଟାଇମ ନେଲେ ଯେ 29/6 ସୁଦ୍ଧା ଅବଜେକ୍ସନ ଫାଇଲ କରିବେ 29/6 ରେ ଫାଇଲ କଲେନି 3/7 ରେ ପୁଣି ଆସିଲା 3/7 ରେ ପୁଣି ଟାଇମ ନେଲେ ଆଜିକି ରହିଲେ କେସ୍
ଅବଜେକ୍ସନ ଏଥିରେ ଫାଇଲ କଲେ କ'ଣଟା ହେଇପାରିବ?
15,000 ଟଙ୍କା ହେଇଥିଲା
In fact, what we are now discussing, we are discussing your objection only.
after କହିଲେ
The only option left is that the interim order should be vacated and you should
Lordship, short date may be
work your remedy there before the executing court. Just keeping the matter pending leads to nowhere.
Your Lordship, short date may be granted.
Short or long is not important. To arrive at a decision is important. Your name, sir?
S. Subham.
S.
Subham.
S. Subham.
My lord, your lordship, kindly see, my lord, 1 minute. Your lordship, kindly see order dated 19/5.
Yes, yes.
19/5 ରେ ସେମାନେ ଅନ୍ୟ ଜଣେ ଠିଆ ହେଇଥିଲେ ସେ କହିଲେ ଟାଇମ ନେଲେ
I am there only.
ଆଜ୍ଞା
Prafula Chandra, Mr. P.C. Acharya for the opposite party. Adjournment is sought for Learned Counsel for the petitioner in absence of the arguing counsel. The Learned Counsel appearing for the opposite party, wife and child, submits that the amount of rupees 7,500 is being paid.
Yes.
The amount of rupees 7,500 directed as an interim measure in IA 185 of 2022 by order dated 14/12/22 by the coordinate bench is being paid, but which is inadequate considering the needs of the grown-up child as well as the ever increasing daily household expenses. Stop. He reiterates his prayer made in the IA 185. 185. ଆପଣଙ୍କ ଆଇଟା ଆଉ ଗୋଟେ 534 of 2024. ଆପଣ ଆଏ କାହିଁ
534/24.
Yes, 534 of 2024 for vacation of the interim order dated 14/11/2022. He submitted that for continuance of the interim order, the amount of rupees 7,500, the reduced amount of maintenance of rupees 7,500 needs to be increased to a reasonable amount to ensure sustenance of the wife and child.
Only child man, wife by kichi nahi.
Acha, for the child. The Learned to objection कौन देवे? ମୁଁ କହିଥିଲି wife ବୋଲି ଆପଣ objection ଆପଣ ତ ଆଉ ଗୋଟେ ପ୍ରକାର level କୁ ପଳେଇବେ. Strange actually. We are really discussing strange things. Only. Child. Para the learned counsel for the petitioners has adjournment to obtain instruction. Yes, next. The matter shall be listed for orders in the week commencing
3
3/8/2026. Not earlier, 27/7. 27/7/2026.
ଟାଇମ କାଲି ଦଉଛନ୍ତି ଆଉ 19/5
ଆଜ୍ଞା ଏଇଠି କିଛି କରିହବନି। ଆପଣ ଯଦି ଏକ୍ଜିକ୍ୟୁସନ ରେ ମୁଭ୍ କରିବେ ହବ, ବଟ୍ ସେ ଷ୍ଟେଜ ତ ଆସିନି। ଦେଖିବା ଗୋଟେ ଏଣ୍ଟ୍ରି ମଡେଲ ଗୋଟେ କୋର୍ଡିନେଟ ବେଞ୍ଚ କରିଛନ୍ତି 7,500 ଦଉଛନ୍ତି।
ସେତେ 22 ମସିହାରେ
ଠିକ
ସେତେବେଳେ
ଅଛି।
ପିଲାର ବୟସ ଥିଲା
ଆଜ୍ଞା, 22 ମସିହାରେ ବିଲକୁଲ ଦଉନାହାନ୍ତି।
ଇଏ ରେଲୱେ ଇଞ୍ଜିନିୟର ଅଛନ୍ତି ନା
ସେ ଆଜ୍ଞା ତାପରେ କହୁଛନ୍ତି ଆଜ୍ଞା କାରଣ ଆପଣ ଆଇଏରେ ନୋଟିସ କାହିଁ ଇସ୍ୟୁ କରୁନାହାନ୍ତି। ଆମେ ଦବୁନି କଣ ଅସୁବିଧା ହେଲା, ଆଇଏରେ ନୋଟିସ ଇସ୍ୟୁ କରନ୍ତୁ। ଆଇଏରେ ନୋଟିସ ଇସ୍ୟୁ ହେଇକି ବର୍ତ୍ତମାନ 4-5 ବର୍ଷ ହେଇଗଲାଣି ଗୋଟେ ଗୋଟେ ମ୍ୟାଟର। ଆଜି ଏବେ ଲିଷ୍ଟ ହଉଛି 22 ମସିହା ଗୁଡାକ ଏବେ ଲିଷ୍ଟ ହଉଛି ନା ଆଗରୁ ତ ଲିଷ୍ଟ ହଉନଥିଲା।
ନା ଭେକେସନ ଷ୍ଟେ ତ ଆମେ ତାଙ୍କର ଅବଜେକ୍ସନ ଟା ଦେବେ ସେ ତ ଆମେ ଫାଇଲ କରୁ
ଅବଜେକ୍ସନ ରେ ଆପଣ ଅବଜେକ୍ସନ ରୁ କଣ ମିଳିବ? ଆପଣ ବି ୟୁ ଆର୍ ଓଭର ସିମ୍ପ୍ଲିଫାଇଂ ଥିଙ୍ଗସ। After considering your submissions only, I have changed the tenor of the order. Although simply the one line is that he seeks time to file objection and time may be further 2 weeks time. So सेटा काहे लेखा हेलानी?
ସେ 24 ମସିହାରୁ ଟାଇମ ନଉଛି 24 ମସିହାରୁ ଫାଇଲ ହେଲାଣି
ସେ ଆଜ୍ଞା ତଥାପି ଚଳିବ। ଆପଣ ତ ଦେଇକି କିଛି କହୁଛନ୍ତି 7,500 ତ ଦଉଛନ୍ତି। କଣ ଲେଖିଲେ? 27/7. Yes.
Item 27.
Peremptory no ଆପଣଙ୍କର ସେ ଆପଣ ଅର୍ଡରଟା ଅପଲୋଡ ହେଲା ପରେ ଦେଖିବେ। It touches different aspects actually of your submission. Peremptory ହେଲେ କଣ ଆପଣଙ୍କ ତାଙ୍କ ପିଟିସନ ରେ କଣ ଭେକେଟ ହେଇଯିବ? This petition he has not obtained entry order. Peremptory କୋଉଠି ଗୋଟେ କାଉଣ୍ଟର ଦିଆ ହୁଏନି। ଆପଣ ତାଙ୍କ ପିଟିସନ ରେ ଗୋଟେ ମଡିଫିକେସନ ଫାଇଲ କଲେ obviously you have that has been highlighted. Yes, 27, Mr. Yes, madam.
On behalf of Mr. BP Dal, he is out of session, therefore I pray for an adjournment.
Lawsuit judgment is there, everything is.
Yes. That is how he's not stationed in the station. Your name, madam?
S.S. Nanda.
Sorry, I forgot actually.
S.S. Nanda.
S.S. Nanda. Ms. S.S. Nanda, on behalf of Mr. V.P. Dhal for the petitioner, Mr. Suraj Mahanti for the opposite party. The matter was earlier extensively heard on 12/2/2026 and IN number 67 of 2026 was disposed of by judgment dated 12/2/2026. Thereafter, the matter has been adjourned on all occasions by the learned counsel for the petitioner. On 23/2026, 22/2026. Start today, the matter being listed for orders, adjournment is sought for in absence of the learned counsel for the petitioner. To grant further opportunity to the petitioner, the matter shall be listed for orders in the week commencing 10/8. Yes, next please.
Item 29.
Case as per MP, the notice issued by this.
Press
notice.
Discover कले फाइनांस एड्रेस पाइना कौन प्रेस कौन टा नेबे Mr. Prem Kumar Mohanty, additional standing counsel for the appellate. Explain the respondent none. Office note indicates that notice issued on limitation has been returned undelivered with postal endorsement insufficient address, hence returned to sender. The learned counsel for the appellant submits that the notices were taken in the available address as per the records of the learned referral court. He he seeks further 3 weeks time to obtain present correct address to take notice afresh. Upon filing of the requisites in the present correct address, notices shall be issued afresh to the respondent, fixing returnable date. The matter shall be listed for orders in the week commencing 26/8/2026. Reported to mention. Next, please.
Item 30.
Item 30, I am for the petitioner, your lordship. Why?
Yes, Mr. J.K. Mahapatra for the petitioner.
On
Whatever. Silly.
my lord.
Yes, Mr. Swarup.
Visire, my lord.
Yes.
Yes, my lord. My lord has instructed for doing consultation of parties so as to the maintenance, and it is going on, my lord.
Mr. J.K. Mahapatra for the petitioner, Mr. Om Swarup, Deputy Moderator. The Lord Counsel for the opposite party being present in DC are Justice Abdullah. The Lord Counsel for the opposite party refers to the order dated 36/2026, wherein the efforts of the Learned Counsel to arrive at a mediated settlement, arrive at an amicable settlement acceptable to both parties, was recorded. What's more details? It is submitted that further time is necessary to achieve a settlement acceptable to both the parties. Stop. Accordingly, the matter shall be listed for orders in the week commencing
17/8.
Yes.
Yes, next, please.
31.
Ms. Pratyusha Naidu for the petitioner.
My lords, may kindly look at order dated 11/3/2026. Para number 18 months.
11/3/2026.
My lords. My lords have directed the Learned Counsel for the Union of India to get certain documents with regard to the salary particulars of the present petitioner.
Yes. Yes. Then what? They have not.
They have not. My lords, my learned senior is also.
Samantray. Ms. Pratyusha Naidu for the opposite petitioner, Mr. Vrindavan Raut for the opposite party. CGC. Upon senior panel counsel. मिलिला किसी कौन पाइले
सर नेक्स्ट वीक रखले मु कोटा आसे
दीटा डेट से जाई से जानी बर्तन 1000
आपण तो पाबनांती बोली बर्तन मु लागि ता पछरे आपण मिस नाइडू बहुत पारले मु करे बर्तन जने आसिले से लागि छन कोन ऑर्डर
एड्रेस मो पात्र अछि जे से मायनमार रो अछंदी बोली सब दिन से अछि एवं से पूरा बर्तन गार्डियनशिप आर्ट फाइल करछंदी मे रे नोटिस दिला पर 4 जुलाई रे थिला फैमिली कोर्ट जाजपुर रे
मिस्टर राउत आपण को बुझिले कोन वी आर डिस्कसिंग समथिंग एल्स regarding the plea taken that inadequacy of the salary or otherwise, so that they will obtain the specifics. It we are roping in the employer. आपण कहलेनी ताको माने अदर साइड को विषय रे कोछ we are not discussing regarding सीधा जुआड जा कोछ
इंटर मॉडल टा जोटा अछि मोड वैकेशन स्टे पर इंटर मॉडल जो 40000 अछि हमर मेंटेनेंस का सेटा 15000 चलछि जोटा आगुरु कोऑर्डिनेट बेंच करथिले सेटा जोटा
कि कूल माइंड रे एटा रिप्लाई करिवे देखिवे व्हाट इज बीइंग डिस्कस्ड
हां सेही
and how you are
all discuss man all
how you are spoiling that
ना
आपण आगे सीजीसी नोंती तो काई ताले कहउछन सी तो कहले मु बुझी कहि बोली
से आनिबेनी जाने दिनटा डेट डला
से आनिबेनी सेटा मु से प्रिजम्पशन देयर इज नो प्रिजम्पशन इन लॉ दैट सीजीसी आनिबेनी और सेंटी कोन करियो
ना आपण
you are making it
I am the victimized man the child is suffering man
आपण कोन victimize हे गले
petition जो
was it your effort to find out did you file any document certifying the salary of your
yes madam 1,60,000
so which is the document you have filed before this court बर्तन आश्चर्य हे जिवे आपण जेतु आश्चर्यजनक सबमिशन करिवे the result will be आश्चर्य also. So because there is a lot of lot of difficulty in your part to say that.
Page 19 my lord.
Page 19 कहते what is the document पचले सीधा कहिवे कौन सेटा?
So salary slip. Pay slip for the month of May 2021 my lord.
वर्तमान में केबे अछि?
21 अनुसार जोटा भी हेइतला सेटा में पाइ पन
आपण जो पाइ पर नांती सेटा वेरियस रीजन अछि सेटा एनफोर्समेंट आपण एग्जीक्यूशन पाइ 15000
it is pending due to
so
order.
we are at a stage where we are trying to understand how much he is receiving or what is our emoluments or whatever से को रिटायर करछन ना कोन
ना pending
ठीक अछि तल स्टिल बेटर आपण सेटा को हाई वर I mean why you are interfering in that process?
40,000 or 15,000
this is classic case where they are fighting it here and maybe they are together. आपण बुझी पार नांती what you are saying. Why you are interfering in in the court's effort to know the truth?
इंटरफेरेंस मोर मोटिवेशन जो हमर हेतला जे जो डिस्कशन हेतला 2003 रे आपण जो लॉर्डशिप
एटा आपनकर सैलरी जणा पडला पर कोन हो
एनहांस हो
ताले काई पर व्यस्त होचन ताले
मु व्यस्त होने
are we not spending time for nothing?
तो लास्ट टाइम
आपण जदी adequately अप्रेस 21 परे आपण पाखरे किसी डाटा नाही सो आज ऑन डेट सो ही इज
तमने मु आरटीआई अप्लाई करथली से रिफ्यूजल देलेनी
कोन हला
आरटीआई रे जो एप्लीकेशन देथली से मना करथला देलेनी
सो आपण निजे बुझी पाले तो बता काई की कोर्ट ऑर्डर कले
आज्ञा
अब ताले फिर कोन असुविधा हैला appearance. The learned CGC submits that as directed by order dated 11/3/2026. He has sought for instructions which is awaited and the matter may be. How much time, Mr. Samantra?
15 days time.
आपण कोन ताके सर्विस जेचंती
नाही मग काय की
तो सेति में बेसी पार्ट तो करछन ना कोन काळे
मो अनजाइट
नहीं सॉरी माने आपनकर ये एटा भी इंटरेस्टिंग आपण 10 दिन रु टाइम नहीं चलचंती ऑफ कोर्स आपण में रिकॉर्ड्स नथिला मे बी अनदर 1 मंथ 4 मास रु तथा भी आपण टाइम नहीं चलछ इन टर्म्स ऑफ ऑर्डर डेटेड 11/3 yes the learned counsel for the opposite party submits that adjournment has been granted for more than 4 months without any instruction from the employer of the opposite party. As prayed for by the learned CGC, the matter shall be listed in the week commencing 3/8/2026. 31 is next time 3/8/2026. 3/8/2026 for orders.
Interim orders to continue.
Interim order, it is so and so shall continue. 23/7/25 shall continue till the next date of hearing. Yes, next.
Item 32.
My lord. So Samantra, you have to get the details of employer, employment, everything. You go through that order. Yes. With the DTO, what is the amount?
My lord, I am submitting from Noyad Virtual Court, my lord.
Yes.
My lord.
They are seeking adjournment.
No, my lord, see, in this case, what happened, my lord? PFM, my lord, I have filed, my lord.
Yes.
And I am paying, as per the direction of this honorable court, I am paying the maintenance. My lord, he
my
has,
lord.
he has filed.
VC problem hoga. If you start speaking,
my lord,
it will not be audible.
I have in the family judge, my lord, I have filed an application on section 9 that was allowed. Challenging the same, he has preferred an appeal before this honorable court. And in this honorable court, my lord, he has submitted that there is a amicable settlement, imminent possibility of amicable settlement, and both the parties shall rejoin the matrimony. My lord. On his submission, my lord, she has not joined, my lord. For that reason, I have filed an application for divorce on 13th.
She works at Bangalore.
My lord.
Airport.
Present petitioner is Bangalore, man. So my application
They appeared before us in the division.
again. By when your lordship sitting
Yes, in the MATA.
my application for divorce was stayed.
They have to achieve something.
But their conduct is not, my lord, to settle the matter. Neither they
it is a MATA रे आपन stay हिच.
stay.
But केबे कोची MATA टा.
एमटी आउ आज्ञा से आउ लिस्ट है
एटा अर्जन हो देखिबा आपण कहउछन जे जेतु सेठी अछि आरपीएफएम रे विशेष किछि करिवार नै
I am paying
I cannot take up the other aspect. Yes, Mr. Potbarik.
My lord, this is a separate issue. My lord, in this case, in the previous year, in previous date, 1/5/2026, this honorable court passed an order directing the trial court, executing court to proceed the execution proceeding as per law. But the lower court has not proceeded the same as per law. Time for a time scale they chalisanti. Kutaro time petition they chalisanti.
Mr. Barik, the executing court is granting because he is paying 10,000. You must appreciate that also. If he is paying 10,000, why the executing court will be? Why not take grant time? Paying the amount.
ଦଉନାହାନ୍ତି ମାଇଲ ଟୋଟାଲ ପଇସା ଦଉନାହାନ୍ତି ବୋଲି ପାଲଟା ହେଇଛି ନହେଲେ କାହିଁ ହେଇଥାନ୍ତା ପଇସା ଦଉନାହାନ୍ତି
ପଇସା
ପଇସା ଦଉନାହାନ୍ତି
ସେ କହୁଛନ୍ତି ଆପଣ ଗୋଟେ କାମ କରନ୍ତୁ you give the details of the payments.
I will file with a video.
ତାପରେ Mr. Barik ଆପଣ in this kind of matters you have to also be serious in your MATA. In MATA 9 order has been challenged in MATA. In that MATA 13 has been stayed, hoping that there will be a amicable settlement.
My lord, in that respect.
So the problem is that almost for 2 years it is continuing.
My lord,
that pain. So you have to make an effort to resolve the matter.
My lord, ସେଇଟାରେ ଆମେ କହିବାକୁ ଯାଉଛେ
you must understand that this relationship may not have any future. Upon mane both Mr. Tripathi and Mr. Barik will be engaged and appear before the court. That is the only silver lining in the entire affair.
My lord, ସେଇଟାରେ ସେ ଦି ଜଣ ଯାକ ରାଜି ହେଇଥିଲେ ଯିବେ ବୋଲି ସେଇଟାରେ ଅନରେବଲ କୋର୍ଟ
ଆଜ୍ଞା ସେଇଟା ତ ହେଇ ପାରୁନି ବର୍ତ୍ତମାନ ପର୍ଯ୍ୟନ୍ତ
ଏ ଗୋଟାକ
ରାଜି ହବାଟା ବୋଧେ I think it is almost now 6 months.
ସେପଟେ ଆଜ୍ଞା ତଳ କୋର୍ଟରେ ଗୋଟେ ଫାଇଲ କଲେ
ଏଇଟା Mr. appearance ଡାକିଛି ଡାକିନି
ତେଣୁ ସେ ଟଙ୍କା ଦେବା ପାଇଁ ଅର୍ଡର କରାଯାଉ ହଜୁର
item 32 Amitabh Tripathi for the petitioner, Mr. Rabindranath Barik for the opposite party. Mr. Barik जने लोक जदि जने दउची ताको आपण ट्रीट करंतुनी आज if he is a non compliant person, that creates a situation they think that they are lesser individuals. So you have heard Mr. Tripathi will file affidavit indicating the amounts paid so that you can know that आपनकर instruction थिबो जे आगे दउ नांती तार तो किछि माने नाही ना. Mr. Amitabh Tripathi for the petitioner, Mr. Rabindranath Barik for the opposite party. Para 5 re apana. Para 5 has not been complied with. Regarding the order dated by order dated 152026 after hearing the learned counsel for the parties. At paragraph 5. So at paragraph 5 the following was directed. Paragraph 5 ta quote kar dele. It is submitted by the Lord Counsel for the petitioner that the petitioner goes on paying the amount. The petitioner shall file affidavit indicating the details of payments made in brief, such as amount paid, date of payment, mode of payment by the next date Upon serving copy thereof on the learned counsel for the petitioner, the matter shall be listed for orders in the week commencing
10/8.
10/8/2026. The next matter लिखिए RPFM 68 of 2025. In view of the order passed in the that RPFM 173 of 2025. The matter shall be listed along with the said RPFM on 10/8. For orders in 10/8/2026.
33.
Yes, next. 33, since time is over, I cannot continue. I have to attend something. Otherwise, I would have continued. 33 केवे चाहते मिस्टर सामंतराय?
As your lords.
Get कर दियो तो.
Interim order.
3/8.
3/8 इंटीरिम ऑर्डर कौन थिला आपन एडजर्नमेंट थिला
Adjournment.
3/8 ले एडजर्नमेंट कर दो बियॉन्ड तो केटा बियॉन्ड 3 ले 10/8
That's a copy, not
कॉपी फाइनल
ମୁଁ ଦେଇ ଦଉଛି
34 want to withdraw, my lord. That amount is already deposited 21,800. 34 item.
34 मेमो टा देले नी
My lord, I will file the memo by physical presence.
अपन तो एटी ना थी इन फाइल करबी अपन को का कोंदु
My lord, I will file.
request any of your colleagues
Yes, ma'am.
तो दोड़ो गोविंद महापात्र 34 क्या फिर कुमार मान The writ petition stands withdrawn.
Yes, my lord. So I am deposited that amount 21,800.
मेमो टा आनो पड़े सब बारी का मेमो टा आनी से किंतु आपण सामनार ना स्क्रीन भीतर अच्छा पढ़ कर yes स्टेप फोन करी कानिबे आपण मिस्टर महापात्र डोंट क्रिएट दिस काइंड ऑफ सिचुएशन आपण कहबे मेमो देबी हमें मेमो केमते न
My lord, I will file on
37
next time.
काली फ्राइडे आसीबो
Friday has to be.
सिंपली पोस्टिंग कर दियो ऑर्डर page 5 item 36 37 anyone mention
36.
36
I am for OP, my lord.
डेट केबे कर दियो तो
10/8.
10/8 page 6
39 and 54.
yes 39 and 54 similar matter
Same matter. Your lordship will fix a date in August sometime. Interim order be extended. Counter has not been filed.
interim order was a stay order
Stay out.
it is not touched it continues better it should not be touched
No, if your lordship is posting it to August,
no it is not by order it is in computer
that's by computer.
that saves lot of time actually
No, I was praying. I was thinking of praying for a date sometime in
date will be given 39 in the computer they will be giving it 39 of
Who comes in 10/8?
10/8 है विक्रेस
तो सब टिके पड़े 15
24 8 को तो
24 8 को
My lord,
24
item 45, my lord.
just watch कोटे पर नाले confusion हो से actually note करछन 39 and 54
54 appearance पे note कर
अच्छा
The lordship may be lordship I am appearing for opposite party 3 in 39 number item. Lordship may I request you to kindly make it to 25 your lordship. 25th date.
25th.
Item number 39.
25th August
Yes your lordship.
that same to Kori hone actually that's the in fact this week is the best example instead of 4 days we are almost having 2 days cannot work out if you fix a date
appearance
39 like to
appearance
the matter paucity of time intervenes the matter is mentioned by the learned counsel for the petitioner to seek continuation of the interim order ଆପଣ OP 3 ପାଇଁ ଅଛନ୍ତି
OP3 board
Opposite party 3 your lordship.
Mr. Devadatta Kanungo
Yes your lordship. Devadatta Kanungo.
ଆପଣ ନା ତ ନାହିଁ ଆଦେରେ
Yes, Your Lordship. I am for opposite party number 3. I filed my wakalatnama.
Sir, I am not saying no.
Yes,
Please
Your
follow the question. At 4:30 even you are unable to. Sir, where is your name in the cause list or in the case brief?
He appeared today with the
Who then appear kale?
Today only appeared.
Eh?
In the last occasion, Your Lordship.
Date, sir.
No.
Which date you have appeared? In which matter?
Item number 39.
No, to apna verify karantu ago.
Your Lordship.
You see, my entire order actually will be erroneous. You please check whether when did you file the wakalatnama or what is the status? Because in fact, it is not. Rather, it is showing that no one has appeared. That kind of a noting. So, ଆପଣ appear କରିଛନ୍ତି ଗୋଟେ matter ରେ 11923 ରେ.
Yes, Your Lordship. Only item number 39.
अरे 39 रे सर 1 2 3 4टा मैटर अछि. ଆପଣ ଚାରଟା ଜାଗାରେ ନା ଗୋଟେ ଜାଗାରେ appear କରିଛନ୍ତି?
ଗୋଟେ ଜାଗାରେ 11923 Your Lordship.
କହିବେ ନା କଣ ଲେଖିଲେ? appearance ଲେଖନ୍ତୁ. appearance ଯୋଉ କହୁଥିଲେ ଦେବୀଦତ୍ତ କାମ ଲେଖିବେ. ଅପୋଜିଟ୍ ପାର୍ଟି ବ୍ଲାଙ୍କ ରହିଲା. ତାପରେ ଲେଖିବେ the paucity of time paucity of time intervenes, the matter is mentioned at the mentioned by the Lord Senior Advocate appearing for the petitioner at the end of the day's proceeding. He seeks extension of the interim order. Dictator 6-5-2026 passed in IA number 5507 of 2023. The interim order is reiterated and extended till the next date of hearing.
50
Secondary भी सेया हो 11915
बाबू गंडा से आवा
111 just a second sir, just a second. 11919 रे सेया हला. Last matter रे Mr. देवीदत्त कानून को OP3 11923 रे
last year and ଆଉ ଗୋଟେ ଅଛି ସେଟା
54 ରେ भी आपण अपेयर करछन्ती मिस्टर कानून को?
No, Your Lordship.
तर 54 ने भी से
चौवन पे आसेंगे टैग करके एक आसेंगे बस
ठीक है.
सेम ऑर्डर है
54 रे कर देबे
एंट्री ऑर्डर 16 पर
आपनकर गोटे ऑर्डर रे हेले होबो ना अलग अलग ऑर्डर करे पड़ो
ना अलग
अलग करे पड़ो. ठीक अछि. 54 रे से ऑर्डर होबो टू बी टैग्ड with WPC 11903 of 2023 state today.
लास्ट रे ऑर्डर टे इंक्रीम ऑर्डर डेटेड 16/5
चेक करियो. दैट इज टू बी चेक. इंक्रीम ऑर्डर चेक करे पड़ो.
ग्रेटफुल ग्रेट
सर को मैटर कहले?
I love next.
38 yes. Give a date. 38 को डेट कर दियो.
नेक्स्ट
तो नेक्स्ट वीक करियो करो.
Commencing 10
टाइम हे गला के.
My lord, item 43 million. May kindly listed in next.
सत्य साथे कर दियो.
43 million.
Item 45, my lord. Opposite party wife is present, my lord. She is coming from
45 sir.
45 रे opposite party wife is present असंती.
सीधा तो पिपिल appearance नहीं चित्र कौन करा?
My lord, no, my lord. ना शुक्रवार Friday को आसु matter.
They what do you want sir? 45
My lord, one my lord, they are not complying the order, my lord. It बार 25 रे आउ second installment दो ना जो तो वहीं से सफर हो.
You file your application. Non compliant से ले application file करी ताको record को आनंतु and serve it on the other side.
My lord.
Friday नहीं Friday नो. आपण जेबे करिवे सेबे आसीबे करिवे. 45 किसी छाड़ देन से मेंशन आपण आगे फाइल कला परे
Friday मु कर दे Monday to
serve the other side then you mention.
My lord, Friday
Monday be hard.
Friday मु कर दे Monday को आसुना.
आपण कला परे liberty to mention होला.
item 50
Lordship item 50 50 45 कोन कहउछन? Lordship I mean
I am for the petitioner, Your Lordship.
45 she mentioned
opposite. I am opposite party.
So say he alleges non-compliance of the order to pay maintenance.
They may file their objection, Your Lordship.
So
we will reply to it.
Payment tax दो ना हंती. There is a method in doing things. अपन सेटा को आनंद record को.
Yes, Your Lordship.
Lordship item 50.
44. Second item 402 of 25.
Yes.
ସେଇଥିରେ ଏକ୍ଜିକ୍ୟୁସନ ଟା ଅଛି 17
ଆର୍ଜନ ହେଇଛି
ଆଜ୍ଞା ସେ 17 କି ଅଛି
ଆପଣ
ଏକ୍ଜିକ୍ୟୁସନ
402 କଥା କହୁଛନ୍ତି
ଆଜ୍ଞା ଏଟା ଟେକ୍ ଅଫ୍ ଟିକେ ହଉ
କେବେକୁ ଅଛି ଏଟା
17 ତାରିଖ କି ଅଛି
17 ତ ସେଟା ପରଦିନ ପୋଷ୍ଟିଂ କରିଦିଅ
Item 51.
item number possible my lord in the face admission
ମୁଁ ସେଟା ଚେଞ୍ଜ କରୁନି I do not pass any order
Milord, item 51.
Submission ଆଣିଲେ ଫେରେ ଏମିତି ତ ଫ୍ରେଶ ଆଡମିସନ ମ୍ୟାଟର ବହୁତ ସମୟ ହିୟରିଂ ହେଇଯାଉଛି
ମୋର
ସରୁନି actually
ଲିମିଟେସନ ଟା ଅଛି ହିୟରିଂ
let us see let us see
Item number 51.
the order stand
Milord, item number 36.
item number 50.
50 ଆପଣ ଡେଟ୍ କରିଦିଅନ୍ତୁ
22/7 ପର୍ଯ୍ୟନ୍ତ ଇଣ୍ଟ୍ରିମ୍ ଅର୍ଡରଟା ସାର୍ ଆଡଜର୍ନମେଣ୍ଟ ଟା ଅଛି
52 ଡେଟ୍ କରନ୍ତୁ 50
Item 51.
17/8 ମିଷ୍ଟର ତନ୍ମୟ ମହାନ୍ତି ସେ ପଜିଟିଭ ଟାଇମ ଅର୍ଡର ହେଲା
ସାର୍ ଇଣ୍ଟ୍ରିମ୍ ଅର୍ଡରଟା 22/7 ପର୍ଯ୍ୟନ୍ତ ଥିଲା
17/8 adjourn beyond 24/8
Item 51.
ଇଣ୍ଟ୍ରିମ୍ ଅର୍ଡରଟା ଟିକେ ଥିଲା
ସରି ସୁବିଲାନି
ଇଣ୍ଟ୍ରିମ୍ ଅର୍ଡରରେ ଆଡଜର୍ନମେଣ୍ଟ ଥିଲା 22/7 ପର୍ଯ୍ୟନ୍ତ
କହିଲି ଆପଣଙ୍କୁ ସୁବିଲାନି ମୁଁ କହିଛି Lorded counsel for the petitioner being present at virtual court High Court of Orissa at Khurda ହେଲା 50
Milord, 36 item number.
36 ରେ କଣ ହେଲା ସେ ପେଜଟା ପଢା just one second କଣ କରୁছে
36
50 କେତେ
ହୁଇ କମିଛି 10
ଆଜ୍ଞା
ହୁଇ କମିଛି 10
10/8
Item 51.
51 yes
Any date in this month. After notice.
अदर साइड अपेयर करना है
Appear करना है थी.
51 डेट करो
हुई कमिଛି 17/8
17/8 भी
Appear sufficient age sir has been back.
करेक्ट सीट पे पहुंचे अपेयर करी नाहंती बोलो
अच्छा
रीडिंग दैट ओनली
अच्छा Milord,
Item 42.
50 yes 50 जाइए 17/8
Item 42, Lordship.
42 yes
42, Lordship. 42.
Yes.
Lordship. Here I am for the opposite party. So, Lordship, may adjourn this matter. But there is no interim order operating.
no so 42 you want a date
Yes.
42
I mean,
date
I am for the opposite party. Petitioner counsel, I think.
17/8 no the matter is not reached we have already gone more beyond the scheduled time
Lordship.
yes
I may pardon. Item number 29.
again
There is a stay order. Pray for continuation of the stay order.
the order टा माने आपनकर स्टे हे जाइछि
Notice has gone.
entry 29 रे entry order करते नहीं 29 entry order